Sir, this is this minute 31st. My position will go minute.
Huh?
Tender notice has been issued by the Panchayat authority. Milad. I am the
When the tender notice was issued.
tender notice was issued on 2nd January. Milad. No publication. I am the existing leaseholder. Milad. No notice was served upon me.
Is there any requirement for service of notice upon?
As per rules, Milad, notice shall be displayed at the public places. That has not been done.
With regard to the tender notice, notice has not been published.
No, Milad, that has not been displayed in any public places.
How the tender notice was placed?
Milad, it has been placed in the website, Milad.
So that is the today. Nowadays the website is the only thing.
Milad, as per rules, Milad, it has to be displayed in a public place.
Which rule?
Milad, West Bengal Panchayat accounts rules, Milad. Rule 93 of the West Bengal Panchayat, Jila Parishad and Panchayat Samiti Accounts and Finance Rules 2003, Milad.
So when you came to know about the
only 27th, I have 27th.
27 January. You
Great.
Tomorrow.
May I have your
Issue notice.
Yes.
May I have your lordship's kind leave to
It has been affirmed?
No, not yet affirmed.
Leave granted to file and list tomorrow.
May I have your lordship's kind leave to mention one matter. This is one probate matter, your lordship. When the matter was filed, one affidavit of the attesting witness was filed. Thereafter, certain changes were to be made in the cost title. The amendment has been carried out, your lordship, and along with that, two affidavits of two attesting witnesses has been filed. I want to withdraw the second affidavit of the attesting witness.
Why?
Because, your lordship, one of the attesting witness affidavit has been filed, and in the main probate application also, the original that probate affidavit has only been filed, and also the second affidavit which has been filed wrongly, that person is living outside the jurisdiction, your lordship.
Outside the jurisdiction means?
He's living in foreign, your lordship.
So?
Your lordship, so I want to withdraw if your lordship gives.
Now, why you want to withdraw? If both the attesting witness have filed their affidavit in support of the will,
it has been wrongly filed, your lordship.
Or why? Why you are telling wrongly?
It has been filed wrongly, your lordship. Under instructions I'm submitting before lordship, the main PLA which has been filed, only one attesting witness has filed its affidavit, your lordship. In the amendment, after the amendment has been carried out, I only want to file the affidavit of that particular attesting witness, your lordship, and I want to withdraw the second.
What the amendment you are sought for?
The amendment of the cost title, the deceased, the address of the deceased is not matching with the death certificate address.
No, that was allowed.
That was allowed, your lordship.
You carried out the amendment.
J1, yes, J1 has
also
been
filed one affidavit of the affidavit of attesting on another attesting.
Yes,
witness.
your lordship.
So
yes.
why you want to withdraw? Let it be on record.
Your lordship.
There will be no harm.
There will be no harm, but it is creating a defect.
What is the defect? You are not supported your will. Not supported your will.
No. Your consent decree has already been filed or by all the.
Let the matter come. We'll see to that. It is listed.
The matter is not listed. If your lordship will kindly allow it to be under to be mentioned.
Give. Not to be mentioned. It will be listed along with the testamentary matter.
Yes,
yes, my lord's leave to grant, my lord, file the inventory and accounts, my lord. In respect of a PL and two PLA matters, father and the mother. The latest administration was issued on 18 November 23. I am out of time to file the inventory.
Have you filed an application for extension?
There is no application, but it has been signed by the applicant. From the it has been signed from the Madhya Pradesh. So, I'll pray your lordship's leave to file this inventory and account.
But you have to file an affidavit. You have to file an application for extension of time. Then
as your lordship
come with the application.
I'm great.
Your lordship's kind leave. May I be able to ask for leave for drawing up and completion of an order dated 7th of January 2025? I'm out of time by 15
7
days.
January
2025. I had to do it within a week, but I have done it in 15 days. That is why I'm praying for the leave.
Lordship, may I be permitted to mention an extension of interim order application, your lordship?
430.
Lordship, Justice Patnaik's matter pertains to the determination of Justice Patnaik. I'm mentioning upon notice. Item number 63 in Justice.
When the interim order is going to be expired?
Friday, your lordship. Friday. Great. Lordship, may I be permitted?
Let me see.
Lordship, the second page.
Where is the order?
Lordship, 29th November, the second page.
Extended till the last week of January 2025.
Lordship.
With the matters.
And I'm mentioning upon notice.
Appellate side?
Lordship, original side.
Original side.
Suit, Lordship.
कल नहीं अपील ये इसको लाना पड़ेगा ना, लिस्ट में लाना पड़ेगा कल लिस्ट फॉर एक्सटेंशन ऑफ interim order.
Lordship, may I be permitted to mention item number 7 is fixed at 3 p.m. Pertaining to an IPCOM matter. The reason for my mentioning is for a clarification if Lordship would take up such matters since the determination it is fixed for cross-examination today, tomorrow and thereafter.
Which year matter?
20
Item number?
Item number 7 fixed at 3 p.m.
Of the commercial division?
Commercial division. 2024 matter.
2020 suit is of 2015. 2015.
So, IPCOM number is of 48.
Suit is of 2015.
Suit
So
is of-
if the 2015 this court is having determination. If up till 2019 this court is having determination, after 2019 this court is not. The suit is of 2015. So this will be good. Yes.
May I have your Lordship's leave to, my Lord, mention item number 34, my Lord, upon notice. Lord,
Of commercial division?
yes, my Lord. My Lord, we could not enter appearance, my Lord, and the summons, my Lord, probably was served at a place where we are not in possession. Now, my Lord, only thing, my Lord, I do not have to all the documents pertaining to this matter. I am mentioning upon notice. If they, my Lord, supply me with
Who is for the other side?
the plaintiff, Mr. Hare Ram Singh, was appearing. He's the advocate on record. I've given him notice by email. My Lord, if that can be done, my Lord, I can quickly, my Lord, as soon as
For the
possible.
defendant?
I'm for the defendant.
So what can be? Nobody say.
Because eventually, when the matter is taken up, I want my applications to be on board.
What application you
My
file?
Lord, leave to enter appearance and leave to, my Lord, extension of time to file written statement.
When you receive the writ of summons?
A writ of summons, that is the issue, my Lord. Your Lordship will have to adjudicate this. It was served at an address which the bank was in possession of. I am still not in possession of that particular property.
So who has received?
My Lord, someone has received it.
Okay, let it be. Let us see how far this court can go. Then you
Yes, my
mention.
Lord. Only thing, my Lord, if I can take out my application in the meantime.
File your application. When you file the application, let mention.
And also, my Lord, I've seen, my Lord, from one of the from the records, your Lordship has passed an order directing the registrar, my Lord, to file a report as to whether summons have been served or not. My Lord, where and whether, my Lord, Order 5 Rule 17 has been complied with or not, that is yet to be seen. That will, my Lord, help me take out my application.
Let them. If you file the application, it will be taken up for hearing.
May I, my lord, slip to mention, my lord, Lordship will remember this Ranchi matter property which was sold in favor of my client, my lord. Lordship had directed to conduct the survey to ascertain the boundary and topography and the area of the building. Now, my lord, we have been told by the Administrator General that without the help of the Deputy Commissioner of Ranchi, my lord, the survey is not possible. Now, let the matter appear tomorrow as to be mentioned, my lord.
Commercial, non-commercial?
It is non-commercial matter.
Lordship, may I have the leave to submit the affidavit or wakalatnama for the PLR matter?
In which matter?
In a PLR matter.
File in the department.
Yeah, the department wants a leave from the.
Why leave is required?
Because the caveator or the we want to file the objection to that.
What objection?
To the.
You are appearing
we have
for whom? To whom you are appearing?
For the objectors.
Caveator. When you receive the notice of the
we received it in 14th November 24, and the petitioner was unable to get in touch with the.
So you are not filed the affidavit in support of caveat?
No.
No. So you file it.
Leave be granted.
What leave is required? If you want to file an application, file in the department. What leave is required? There is no leave required. If you wanted to file an application.
The department wanted the leave from the.
I don't know how the court can grant the leave. If you want to file any application, you file in the application in the department, then the application will come, then we'll see.
Lordship, may be permitted to mention a matter. Lordship, on 6th of January, this matter was taken up. Lordship had allowed my plea into Lordship. Thereafter, the file was like in the master's chamber for the scrutiny. Lordship, thereafter, there is some.
What order is passed?
Lordship,
What order is passed on 6th January?
Lordship, the plaint was admitted on 6th
Plaint
January,
admitted, yes. Then?
and thereafter it was, the file was with the master's Lordship for the scrutiny.
Ah.
Thereafter, some defect has been found out, Lordship, but thereafter those defect has not yet been informed.
Ah.
The department is saying that I need a Lordship's leave for the defects to be cured.
Ah.
So, I was just humbly praying if your Lordship would keep this matter tomorrow to be mentioned, and if your Lordship would
Have you approached the office?
we have approached the
Ah,
office.
what is the
department
defect?
has said that to get a leave from your honor, Lordship. And in
Unless and
what
until what is
what
the
defects
defect?
have not been told yet, not been told yet.
Let the office submit report. Tell the office to submit the report, then we'll see to that.
Submit the report to the honor.
Yes.
Lordship, at the outset, I apologize, Your Lordship. Item number 7, Saregama versus the New Digital Media that my learned friend just mentioned. There's some misunderstanding on our part only, Your Lordship. There's a new determination that has come on 16th January, Lordship. As per that, it says all matters relating to intellectual property rights and applications connected thereto. They have removed the year differentiation that was there before. So that is why we thought that this matter is before Justice Kapoor now. That is why the witness is not here, Your Lordship. He'll be here tomorrow. We didn't call him today because we thought the determinations have changed, Your Lordship.
Hey, any change in the determination?
16th January 25, Your Lordship. There's a notification that has come.
Nahi mera? To release it. Where is the determination? Show me.
They have removed the year differentiation, Lordship, that was there
But it has
before.
not been given to this court. My determination is not changed. Okay, I am releasing, no problem.
Lordship, I'm not asking Lordship to release.
The matter is listed as to the matter is listed in the days list as item number 7 under the heading specially fixed at 3 p.m. Learned counsel for the plaintiff draw the attention of this court to the determination, partial modification of the roster of the determination of appellate and original site from 20th January 2025 dated 16th January 2025 by notification number 354 RG, wherein with respect of all matters relating to the intellectual property rights and application connected thereto be assigned to His Lordship Justice Ravi Kishan Kapoor. Accordingly, full stop. In view of this determination, full stop. The item number 7 is connected with the intellectual property matter. Accordingly, the same is released from the list of this court with the liberty to place the matter before the appropriate judge.
Much obliged.
May I be permitted to mention a suit, my lord? That the suit has been settled.
एक नोट भेजो आरजी को, एक नोट भेजो by so and so, but my determination please clarify.
The suit has been settled between parties, my lord. They have signed some terms of settlement, my lord. Both the parties, my lord. It is a suit for eviction, my lord. New India Assurance is there, the tenant, my lord. Under my client, my lord. We have settled. They will vacate the premises. My lord, may it appear any time, my lord, subject to my lord.
Settlement is entered.
For settlement, some settlement has been.
What is the commercial, non-commercial?
It is a commercial suit, my lord.
Right.
But it was actually original suit of 2007, my lord. But after it was converted under section 15, it has become a suit of 2024.
2007
suit. Presently, Your Lordship has the determination of both, my lord. Even 2007, Your Lordship, Justice Patanaik's determination, Your Lordship has.
This court will not, cannot.
No, it can be. Because the suit was converted also in 2024, my lord.
Converted?
Under section 15, my lord, we made application.
Transfer.
For transfer, my lord, the suit was transferred.
And
then new suit number has been given, my lord. ECOM 39 of 2024, my lord. Your Lordship can.
Justice Patnaik is having the commercial determination.
Yes.
So, ये तो नहीं पुराना है ना, ये तो All interlocutory application suits including the testamentary commercial kind. The original side, a commercial नहीं. He's not having commercial. No commercial. Okay, Friday to be mentioned.
It's a name. It's a cost center name.
It mean, and by the notification earlier को mention कर देना. This is within now 20th January, but his lordship's determination has not been modified. Please clarify whether it is continue or it is.
Friday has to be mentioned, Lord. Deeply obliged.
Yes, a commercial list for judgment item number 1.
Defendant is directed to pay rupees 20 lakhs 8,276 along with interest at the rate of 24% per annum from 1st April 2020 till the realization of the said amount. Also to pay rupees 1 lakh being the cost within 60 days, failing which the cost shall also carry interest at the rate of 6%. So it is disposed of. Dismissed.
Suit dismissed.
Huh?
Yeah,
No,
application dismissed.
Application dismissed.
Right, to appear for the plaintiff, this is commercial suit. Now, during scrutiny, certain errors have crept in. Like has been leave is required, my lord, to cure those defects, my lord.
Order 37.
Yes, my lord. Order 37.
Consider the parents some of the calls. Four original documents have been produced with the plaintiff by way of an affidavit which contains wrong annexer. Have you gone through the report?
Yes.
So what do you want?
Now, the leave is required to correct those in the documents, my lord.
So appearing for the plaintiff. Full stop. Counsel for the plaintiff submitted by an order dated 7th of September 2024. This court has admitted the plaintiff subject to scrutiny. At the time of scrutiny, department has indicated altogether six defects in the print. Accordingly, counsel for the plaintiff prays for leave to cure the defects. In view of the submission made by the counsel for the plaintiff, the learned advocate on record of the plaintiff is granted leave to correct that and to cure the defects as indicated in the report of the department dated 22nd January 2025 within 2 weeks. Within 2 weeks from date.
Grateful.
In this suit, Lord, I am appealing for the plaintiff, Lord. Lord, it's really a undefended suit, Lord. The defendant is trying to negotiate with my client, Lord, and trying to settle, Lord. Your Lordship was kind enough to adjourn this matter for some time, Lord, in December, Lord. If Your Lordship can give us 2 weeks, otherwise, we shall proceed with the suit some more time, Lord. This is required, Lord.
So appearing for the plaintiff. As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 11th February.
11th February.
Next.
Lord, Your Lordship's question was ringing on my mind, my Lord. Last night I prepared a 3-page note. I will give my nothing new. My Lord, may I just request Your Lordship to give me exactly 3 minutes? I'll take Your Lordship through the note once.
No, with regard to my confusion, that has
no,
been...
not Your Lord, not confusion, Lord. Lordship's question. My Lord,
The question that then you have given the judgment of.
Yes, I have tried to explain. Milord, I'll just take 2 minutes. With my learned friend's permission, Milord, I'll just explain the note. Milord, please take the first page.
First time in 30 years he's taking my permission.
So you thanks to this court.
Grateful to your lordship.
Milord, every night,
Used to
20
torment
people,
me because I used to read the Hanuman Chalisa.
Milord,
All of them.
20 people in the room. Used to play football. 20 people, I was sleepy, 20 people in the room up to 4 in the morning. And in that I had to sleep. On top of that, your lordship knows.
So
Milord,
you can sleep anywhere.
anywhere. After that, Milord, I can sleep anywhere. I can, in fact, go to sleep here, Milord. Also. On top of that, your lordship knows, Milord, Mr. Shobhoshachi Banerjee, the criminal lawyer. Milord, he turns up and says that I have a problem in my spine. So I need to sleep on a bed, you sleep on the floor. So 6 months on the floor. So that is, Milord, the history. Now, Milord, may I, to your lordship, Milord, plaintiff has filed section 9 application. It therefore chose arbitration. Very important. I chose arbitration. I could have also chosen suit, but I chose arbitration. Arising out of the underlying contract. In aid of arbitration, I filed section 9. Bank guarantee tripartite agreement. Milord, question is, could the bank have taken issue of, Milord, I made a mistake. Milord, could the plaintiff have taken issue of bank guarantee injunction to section 9 proceeding? Next paragraph is, Milord, I could have taken to section 9, but not to arbitration. And why, Milord, I have given. Summarized on the second page, bank is a necessary party given the judgment. While in a court, bank can be impleaded. Milord, second page, in section 9, in arbitration, same is not possible. Earlier, even in section 9, view was that third party could not be impleaded, which is why suit would have to be filed. This is why in Bombay they said suit. Then, cause of action of, Milord, central issue is fraud of the bank. So that's why bank is a necessary party. Then, Milord, on the third page, Milord, therefore, while the order dated such and such could be passed by section 9 court, learned arbitrator under section 17 would not be in a position. But by the order dated 7th November, matter was referred for decision before learned arbitrator under 17. Next is not question which would then arise is what could the plaintiff lawfully do to have the order continued once section 9 court decide not to entertain and refer the matter to arbitration. Only option would be to take the issue and claim relating to bank guarantee out of purview of arbitration. For example, Milord, if I file a suit under Order 23 Rule 1, I can take it out of the suit. But Order 23 Rule 1 will prevent me from, Milord, filing again. For that, I need leave under Order 23 Rule 3, which is what, Milord, I have said. I have obtained such leave from arbitrator. Then, no estoppel. And what is, Milord, leave from, what is leave under Order 23 Rule 1.3? That I have explained. And I have said, Milord, that defendant number 1 cannot contend that present suit is barred by estoppel because of the Supreme Court judgment, Milord, paragraph 44, or by Order 23 Rule 1, or say that we are bench hunting. Since judicial order gives me this leave, Milord, they would have to, if they want to say that second suit is barred, then they had to object before the arbitrator when the learned arbitrator was granting leave. Normally, Milord, when we file for, Milord, withdrawal, matter of right. But with leave, matter of discretion. Somebody wants to object, they have to come and object in court because otherwise order is passed. So, Milord, no objection taken. Then they have deemed to have agreed because they have not objected. They haven't challenged and they cannot challenge. And it's a judicial order upon consideration of Order 23 Rule 1A conditions. 1A হবে না 1.3 1.3 হবে. Last night I was thinking 12 o'clock I decided to type it out. So many errors, Milord. Kindly.
Yes.
This is all, Milord. I don't want to disturb
Yes.
my learned friend.
That realization comes to you after 30 years.
Yes.
Lord,
Yes, Mr. Bhattacharya.
yes. Lord, let us look at the plain case which he has made out. If your Lordship kindly takes the plaint ones, volume 1 of the plaint.
Give the plaint.
Page 14, volume.
You are having the plaint has
Plaint
plaint. You are not enclosed, no?
The-
Have you enclosed the plaint?
I do not know, my lord. My lord, paragraph 37.
My lord, I'm very sorry, my lord.
Paragraph 37.
37 at page 14.
Yes.
When the matter was taken up for consideration by the learned arbitral tribunal on 6 January 2025, it was observed that while the defendant number 1 was a party to AP 695 of 2024, being the petition under section 9 of the Arbitration and Conciliation Act 1996, on which the interim orders dated 9 July 2024 and November 7, 2024 have been passed, the said defendant number 1 was not a party or was not present before the learned arbitral tribunal. Bank guarantees being a tripartite agreement, it would not be permissible for the learned arbitral tribunal to proceed to pass orders similar to those passed by the Honorable Court under Section 9 of the Act, having regard to the absence of the defendant number 1. Jurisdictional issue should be avoided by the plaintiff by filing a suit where defendants could be impleaded and adjudication had in their presence. The bank was made a party to the arbitration proceedings in Section 9, though no reliefs were claimed against the bank. Now, my lord, let us just look at the scheme of act. My lord, kindly takes the act prior to 2015. And my lord, kindly takes the Arbitration Act as it stands today. My lord, first let me show the provisions as it stood before the 2015 amendment. My lord, kindly first take section 9. This is prior to amendment. A party may, before or during arbitral proceedings, or at any time after making of the arbitral award, but before it is enforced in accordance with section 36, apply to the court, my lord, for appointment of guardian for interim measures, then my lord, for preservation, interim custody, securing the amount in dispute, detention, preservation, interim injunction, any such other relief. Now, my lord, kindly takes section 17 as it stood before amendment. My lord, kindly looks at section 17. Yes. Unless otherwise agreed by the parties, the arbitral tribunal, at the request of a party, order a party to take any interim measures of protection as the arbitral tribunal may consider necessary in respect of the subject matter of dispute. The arbitral tribunal may require a party to provide adequate security. My lord, there was a lot of difficulties, as Mr. Chaudhary rightly pointed out yesterday, that prior to the 2015 amendment, enforcing orders of the arbitrator was a real problem which was posed. Now, my lord, so there was a law commission report. My lord, may I just hand up the law commission report, which is my lord, 17 was really restricted, my lord. Yes, my lord, I do not. Now, my lord, kindly takes paragraph 46 at page 33 of this report, which the law commission considers. Page 33. My lord, this is the problem which the law commission is talking about in this report. And I will show the suggested changes and which has now come in 15. By way of amendment to section 17 after 2015. Correct. Under section 17, the arbitral tribunal has power to order interim measures of protection.
Which paragraph?
My lord, paragraph 46 at page 33.
No.
Page 33 that?
No, no.
26. Oh, my liquid text. I'm sorry, my lord.
Paragraph
46.
46.
My
Not
PDF
page
copy.
26.
626. My lord, my PDF copy the number.
Yes.
Under section 17,
Yes.
the arbitral tribunal has the power to order interim measures of protection unless the parties have excluded such power by agreement. That is not the case. Section 17 is an important provision which is crucial to the working of the arbitration system, since it ensures that even for purposes of interim measures, the party can approach the arbitral tribunal rather than await orders from a court. The efficacy of section 17, my lord will kindly mark this, is however seriously compromised given the lack of suitable statutory mechanism for enforcement of such interim orders of the arbitral tribunal. Now, paragraph 47. In Sundaram Finance versus NEPC India Limited, I think the judgment was authored by Justice Sujata Manohar, the Supreme Court observed that though section 17 gives the tribunal, I will rely on that NEPC to show the difference now, the power to pass orders, the same cannot be enforced as orders of a court. And it is for this reason only that section 9 gives the court power to pass any interim orders during the arbitration proceedings. Now, Delhi High Court tried to somehow enforce these orders, but they said that is not good enough. Subsequently, in MD Army Welfare Housing Organization versus Sumangal Services Private Limited, 2004-9 SCC 619, the court held that under section 17 of the Act, no power is conferred on the arbitral tribunal to enforce its order, nor does it provide for judicial enforcement thereof. Now, my lord, Delhi High Court, my lord, always proactive, Delhi High Court, in face of such categorical judicial opinion, the Delhi High Court attempted to find a suitable legislative basis for enforcing the orders of the arbitral tribunal under section 17 in the case of Sri Krishnan versus Anand, reported in 2009 3 Arbitration Law Report 447, followed in India Bulls Financial Services versus Jubilee Plots, such and such. The Delhi High Court held that any person failing to comply with the order of the arbitral tribunal under section 17 would be deemed to be making any other default or guilty of any contempt to the arbitral tribunal during the conduct of the proceedings under section 27(5) of the Act. The remedy of the aggrieved party would then be to apply to the arbitral tribunal for making a representation to the court to mete out appropriate punishment. Once such a representation is received by the court from the arbitral tribunal, the court would be competent to deal with such party in default as if it is a contempt of an order of the court, either under the provisions of the Contempt of Courts Act or under provisions of Order 39 Rule 2A of the Code of Civil Procedure 1908. Now, my lord will kindly see what the Commission records. The Commission believes that while it is important to provide teeth to interim orders of the arbitral tribunal, as well as to provide for their enforcement, the judgment of the Delhi High Court in Sri Krishnan versus Anand is not a complete solution. The Commission has therefore recommended amendments to section 17 of the Act, which would give teeth to the orders of the arbitral tribunal, and the same would be statutorily enforceable in the manner as orders of a court. In this respect, the views of the Commission are consistent with, though do not go as far as, the 2066 amendments to Article 17 of the Ancestral Model Law.
Correct.
Now, my lord, apropos this comes amendment to section 9. And section 9, and my lord, it could be page 44. My lord, the page numbers, the pagination is at the bottom of the page.
Yes.
Now, my lord, may I beseech your lordship, my lord, apropos this, now your lordship kindly takes the new act, section 9. This is pursuant to, now 2 subsections are introduced. Subsection 2 and subsection 3. And why it is introduced, that would be evident from the Law Commission report. Where before the commencement, this is introduced in 2015, of the arbitral proceedings, a court passes an order for interim measure of protection under subsection 1. My lord, this was basically, my lord, a statutory recognition of the judicial dictum in Farm Ashok, my lord, which was authored by Justice S.B. Sinha, which says you obtain an interim order under section 9, you keep sitting, you do not invoke arbitration.
Correct.
Justice Sinha said, in such an event, if you don't do it within a reasonable time, the interim order should vacate.
Yes.
That has now found statutory recognition by introduction of subsection 2 to section 9.
Yes.
Where before the commencement of the arbitral proceedings, a court passes an order for any interim measure of protection under subsection 1, the arbitral proceeding shall be commenced within a period of 90 days from the date of such order or within such further time as the court may determine. Next, my lord, subsection 3 is introduced, and the reason I would show what the Law Commission records. Once the
very persuasive.
absolutely, once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that circumstances exist which may not render the remedy provided under section 17 efficacious.
Yes.
My lord, 19 July, the initial order was passed.
Correct.
7th November,
Second
sections go before the arbitrator. They do not tell my lord that the remedy under section 17 is not efficacious. Now, my lord, also takes section 17 now as amended. My lord, kindly looks at...
But Mr. Bhattacharya, this notification inserted by Act of 2016 with effect from
23rd of October 2015.
That notification it's come into force.
Yes.
Come into force.
Yes. 9293.
Please.
No, there was a confusion. This is the same notification about section 11.
Yes. Some sections have been notified.
There is confusion whether this was been taken.
I think this has come in.
This has come in. I will tell your lordship.
But what your lordship
has correctly pointed out. Your lordship had kindly pointed out. My lord kindly takes 11.6a. My lord, because that has been clarified. That caused a lot of confusion in our law books. My lord will kindly see subsection 6a omitted. My lord kindly take subsection 6a. Omitted by Act 33 of 2019, section 3, 5, within brackets. Now the BRF has made this clarification. Date of enforcement yet to be notified. Because, my lord, these powers are to be taken away from court. And institutional arbitration, which is given under section 43A, this Arbitration Council of India. But at the moment this is set up, my lord, those applications under section 11 will disappear. Omitted hoini, bhai. Date of enforcement yet to be notified. But that's your lordship kindly. But 2 and 3 has been notified. There is no doubt. And I will relax. Now, my lord kindly looks at section 70. Your lordship had seen before, prior to amendment of 2015, how restricted section 17 was.
Correct.
Now, my lord kindly looks at section 17.
Yes.
A party may, during the arbitral proceedings, apply to the arbitral tribunal for appointment of guardian. Similar wording as section 9 for an interim measure of protection. Your lordship can see it same. The language is same.
Correct.
Now, as section 9, now, my lord, subsection 2 is introduced pursuant to the Law Commission's recommendation. Subject to any orders passed in an appeal, Because if he is aggrieved by an order of the learned arbitrator, he can file a section 37. Any order issued by this tribunal, the arbitral tribunal, under this section shall be deemed to be an order of the court for all purposes and shall be enforceable under the Code of Civil Procedure in the same manner as if it were an order of court.
Yes.
So, my lord, the relief under section 9 and under section 17 are different. Yes. After 2017, my lord, this argument cannot stand. Now, apropos this, my lord, your lordship will kindly consider the Law Commission report, why these amendments were brought about. My lord, kindly takes page 44 of that report.
So what is your contention with regard to 17 subclause?
17 subsection 2, my lord, is akin. 70 powers under section 17 is same as that under 9.
Correct.
If he could have approached the court for an order and obtained interim order to restrain me from encashing the bank guarantee, same powers the arbitrator could have exercised. There is no embargo after amendment to 2015.
Okay. Then?
My lord, apropos this, my lord kindly takes page 44 of the report. Yes. Why these amendments were brought about.
Yes.
My lord will kindly take page 44. It's at the bottom. My lord, it's the heading starts with amendment of section 9.
Yes.
Now, my lord, the first subsection 6, then Roman 2. After the words any proceedings where the arbitral procedure, my lord, the note that 9.2. This is 9.2, my lord, it talks about where before the arbitral proceedings, a court grants any interim measure of protection under subsection 1. The arbitral proceedings shall be commenced within 60 days from the grant, or, my lord, the statute has said it is 90 days, not 60 days. Its recommendation was 60 days. Now, my lord, will kindly see the note. The amendment is to ensure the timely initiation of arbitration proceedings by a party who is granted an interim measure of protection. Next, subsection 3. Once the arbitral tribunal has been constituted, the court shall ordinarily not entertain an application under this provision unless circumstances exist owing to which remedy under section 17 is not efficacious. This entire subsection, as recommended by the Law Commission, has found verbatim, has been quoted verbatim in subsection 3 of section 9. Now, my lord will,
yes,
my lord will kindly see the note, why this was done. The amendment seeks to reduce the role of court in relation to grant of interim measures once the arbitral tribunal has been constituted. After all, once the tribunal is seized of matter, it is most appropriate for tribunal to hear all interim applications. This also appears to be the spirit of ancestral model law as amended is 2006. According by the Supreme Court.
Yes.
2022 1 SCC 712.
2022?
1 SCC 712. কোথায় গেল? My lord, kindly takes paragraph 61 onwards. At 60, my lord.
Yes.
A civil court of competent jurisdiction thus has the jurisdiction to admit, entertain, and decide an application under Section 9, subsection 1 of the Arbitration Act at any time before the final award is enforced in accordance with Section 36 of the Arbitration Act. However, subsection 3 of Section 9 of the Arbitration Act, on which much emphasis has been placed both by Mr. Khambata and by Mr. Kapil Sibbal, provides that once an arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that circumstances exist which may not render the remedy provided under Section 17 efficacious. 19th of July is the first interim order to extend it. 23rd November, they've been asked, they're given leave to approach the arbitrator. They do not say that this won't be an efficacious relief. Subsection 3, paragraph 62 of Section 9 has two limbs. The first limb prohibits an application under subsection 1 from being entertained once an arbitral tribunal has been constituted. The second limb carves out an exception to that prohibition if the court finds that circumstances exist which may not render the remedy provided under Section 17 efficacious. Now, paragraph 63, my lord. To discourage the filing of applications for interim measures in court under Section 9(1) of the Arbitration Act, Section 17 has also been amended to clothe the arbitral tribunal, my lord will kindly mark these words, with the same powers to grant interim measures as the court under Section 9. Now, next paragraph, very important, my lord. The 2015 amendment also introduces a deeming fiction whereby an order passed by the arbitral tribunal under Section 17 is deemed to be an order of the court for all purposes and is enforceable and as an order of the court with the law. Now, my lord, paragraph 64 is very important. With the law as it stands today, the arbitral tribunal has the same power to grant interim relief as the court, and the remedy under Section 17 is as efficacious as the remedy under Section 9(1). So his pleading in paragraph 37 of the plaint, my lord, that dehoes the law as it stands today after the 2015 amendment. There is therefore no reason why the court should continue to take up applications for interim relief once arbitral tribunal is constituted and is cessation of the dispute between the parties, unless there is some impediment in approaching the arbitral tribunal, or the interim relief sought cannot be expeditiously be obtained from the arbitral tribunal.
What about the tri-party agreement?
My lord, I will come to that. Mr. Chaudhary himself has relied on a decision of our court. I have a Maharashtra Law Journal also, but I will rely on both. 2021 SCC Online Calcutta 2986. Mr. Chaudhary himself had relied on.
2021
SCC Online Calcutta 2986. That is reported in AIR. Also, the equivalent citation is AIR 2022 Calcutta 207.
Yes.
It could make the bank a party.
The citation, the AIS citation is wrong.
Oh, right.
Yes, that this is not correct. The AIR citation is not correct.
The AIR citation is wrong.
Oh, that's why. AIR citation. So we'll go by the SEC on.
SEC on. My lord, kindly takes paragraph 20.
Yes.
With regard to the objection taken on behalf of the respondent number 2, that a non-party to an arbitration agreement, my lord, here it was the bank,
Yes,
cannot be impleaded in the present proceeding. This court is of the view that Section 9, read with Section 2(1)(a) of the 1996 Act, provides for a right to apply for interim relief only to a party to the arbitration agreement. There is no embargo, however, in provisions against implementing a non-party to an arbitration agreement where the presence of such non-party is necessary, and they had impleaded the bank, is necessary to give effect to the order that may be passed in the application against a party to the arbitration agreement. The petition contains an averment that the respondent number 2 has been impleaded for effective adjudication of the issues involved. There also the respondent 2 right?
Citibank.
the same bank.
Citibank. No, in this section 9, the respondent, the bank was impleaded as a party, though no reliefs, as a pro forma respondent. There was no embargo under section 17 to do that.
Can't be done.
Please, just I did not enter. There is no embargo, however, in the provision against implementing a non-party to an arbitration agreement where the presence of such non-party is necessary to give effect to the order that may be passed in application against a party to the arbitration agreement. The petition contains an averment that the respondent number 2 has been impleaded for proper and effective adjudication of the issues involved in the present proceedings. The pleadings finds factual support from the petitioner applying for a bank guarantee to be issued in favor of the respondent number 1, which was impleaded by Citibank NA, Kolkata, issuing a standby letter of credit in favor of Citibank NA, Bangladesh at Dhaka, who in turn issued a performance security in form of a bank guarantee. Hence, in order to seek an order of injunction, and in the event of such injunction is granted to be effective, respondent number 2 has been made a party to the proceedings and relief sought against it. The issue of maintainability is answered in favor of the petitioner. My lord, even earlier, Maharashtra Law Journal, Taj Trade. 1992 to Maharashtra Law Journal 158.
Page 9.
I'm just my lord. L. Well, it kindly comes to paragraph 5. No.
Yes.
Reliance was placed by Mr. Nitin Thakkar on behalf of the first defendant on the decision given by Dhanuka J in arbitration. Now, it is true that Dhanuka J observed that the party at whose instance furnished is not a party to the contract of bank guarantee. Now, my lord, the A of the code. But, and I say with respect, this observation appears to me to be in direct conflict with what the Supreme Court held in Punjab National Bank's case on the meaning of guarantee as defined in section 126 of the Contract Act. I therefore hold that the dispute regarding invoking the bank guarantee is referable to arbitration. Now, my lord, just to also, my lord, for my satisfaction about certain other statutory changes made in 2015. My lord, we know that Arbitration Act is a complete code. There is no bar My lord, if your lordship kindly takes section 8. There is no bar to filing a suit. Had he filed a suit, had he filed a suit and it's a commercial suit within 120 days, I do not file an application under section 8(1). I waive my right to go for arbitration. So there is no bar of suit which has been provided in this act. But once you elect to go for arbitration, can you then turn around and say, no, I will again come to civil court? Now, my lord, this also, section 8, as it stood prior to amendment, if your lordship kindly take section 8, this has also, my lord, kindly take section 8.
Yes.
A judicial authority, prior to the amendment.
Yes.
Before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party so applies, not later than submitting his first statement on the substance of dispute, refer the parties to arbitration. The application referred to in subsection 1 shall not be entertained unless it is accompanied by original arbitration agreement or duly certified copy thereof. My lord, I will tell your lordship, there are certain Delhi High Court decisions which says that if you take the point of arbitration in your written statement, that should be constituted as an application as section 8.
Correct.
So, my lord, this matter came up in ArcelorMittal, and my lord, I have been led by Mr. Mukherjee, who found out a New Zealand law report, Karate versus Karate, his amazing research and his oratory skills, which is stare materia similar with our statute. And Justice Mantha held, no, if you take that point in your written statement, that is not good enough. You have to take out a separate application.
Just recently, Justice Bhattacharya has passed in the
Yes,
in the appeal.
Yes.
Just, I think, 9th January or some.
So you have to take out an application. Taking that point in your written statement will not do that. Now, kindly looks at the new amendment. Because Sukarna holding, my lord, what we used to do is we used to add 5 other parties who might not be relevant. And we would say that you cannot bifurcate the cause of action. So Sukarna Holdings said if it cannot be bifurcated, it cannot be referred.
Yep.
That has been taken care of by the Law Commission, and Sukarna Holding is no longer a good law.
But with regard to the sum,
So, sir, I will show, my lord, that also judgment I am carrying of Justice Bhattacharya. Now, my lord, kindly looks at section 8 as it stands today. A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement, or this has been added,
correct,
any person claiming through him or under him, the scope has been enlarged.
Yes.
And my lord, though it is not too relevant, but for my lord, this has been considered by Justice Bhattacharya, where I was at the receiving end and Mr. Chaudhary was the victor. Yes.
That is in that
section 11.
suit.
2022 1.
That is different matter.
2022
Section
SEC online 170. No, I will just show where Sukarna Holdings stands today.
Paragraph 34. What portion is good? Kindly come to the paragraph.
Yes, 130. The conclusion without a doubt is that Sukarna Holding is no longer a relevant factor for court to consider at the stage of reference in an application under Section 8. Even today, if he had brought a suit, if I can show that these disputes are covered by the arbitration agreement, he could not have pressed Sukarna. The court is not even under a mandate post-amendment to adjudicate the bifurcability of the causes of action or the presence of parties who are necessary parties to action, but not to arbitration. The only break in the momentum of reference is the court finding prima facie that no valid arbitration agreement exists. My lord, paragraph 36 also it is considered.
38, 7 and 8. Referred to arbitration.
And it was referred to arbitration.
Yes.
Now, my lord, kindly takes the arbitration agreement. Whether তুই এতদিন ধরে বলেছিস আমি
জিজ্ঞেস করছে কতক্ষণ
কোথায় গেল arbitration agreement? দাঁড়া আমার এখানে 40. But kindly takes the arbitration agreement, which is at page 40
of this application.
Of the application. IAGA number 1.
Yes.
12টা fix আছে.
How much time will take?
My lord, if your lordship,
For that time.
my lord, a little bit more. Half an hour will do.
ना अपीलेट करती हूँ बाहर से है ना सब 3 PM क्या है 3 PM क्या है अच्छा can come at 3
yes madam
yes
come at
yes
3
yes
Lord, even if I am on legs, Milord, I'll just request for 10 minutes tomorrow.
no problem no problem. Let Mr. Bhattacharya come.
Yes
ठीक है आराम से इतना इसमें हाँ 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 किसमें हाँ फर्स्ट वाला 1 मिनट सेकंड में तो एक ही तो हम डिस्पोज किया Yes, call the applicant.
Mentioning. Lordship, I would like to mention a matter, Lordship. May I be permitted?
This is not the time for mentioning, madam. Sorry. Yes.
I'm for the petitioner in the item number 1, that is 1130 fixed matter, Lordship. Lordship, here I have challenged the decision of.
You are for the petitioner?
I am for the petitioner, madam.
I beg to appear on behalf of the state.
You are for the state?
My lord.
Yes.
Lordship, in the outset, Lordship, I want to submit that the translated copies are required. I have translated it, though these are unofficial translation, Lordship. One. Last notice to the journal. Lordship, kindly come straight away to the notice. I am agreed by the decision of the Panchayat to hold a second meeting, which is annexed in page 29.
Where is the decision of the first meeting?
First meeting's decision is annexed in page 31.
You are having the translated copy?
I have the translated copy, Lordship. Though these are not official translation, however, I am handing it over.
Give the copy to him so that he can.
Yes. In that meeting, Lordship, there are 26 members in total.
How many members in the Panchayat?
26 members in total.
Including Pradhan?
Including Pradhan. 13 members, they have casted their vote. It was an open vote as per the statute. And 13 votes were casted against the motion, that is the budget proposal. Therefore, Lordship, it was 13 and 13. On that day, the minutes of the meeting records That 13% they have casted the vote. Pradhan did not cast his vote.
During the discussion, some members, including opposition,
And they have abstained from casting their vote, the opposition. So all votes were casted against the motion.
Yes.
Rest of them abstained from casting their votes.
So 13-13 equal.
They abstained. They have not exercised their right to cast their vote, either in favor of the motion or against the motion. That was the situation. Now, Lordship, whatever it is, whether the decision arrived in that meeting, can it be altered by calling for any subsequent meeting? That is the moot question which we have to address. Now, Lordship, after this meeting, this is the notice which is under challenge, which is in page 29. Is it correct? Lordship, this is the translated copy. You are hereby informed through this notification that the special meeting of the Gram Panchayat has been convened on 9/1/2025. This was the earlier, and now in the same agenda, with the same agenda, the same agenda has been reintroduced in the next meeting, whether that is permissible under the Panchayat.
This is the first notice. Annexer P2.
P2. That is the first notice.
Yes.
Now, second notice,
First notice, after the first notice, this
meeting held.
This is the minutes of the meeting.
Meeting held.
Approved.
13% casted their vote for the motion. Rest of them abstained from casting their vote.
Correct.
Now, Lordship, the next notice comes after this meeting was held. This notice was issued on 21/1/2025, wherein the next date for the meeting is fixed on 29/1/2025. That is day after tomorrow. Now, whether the same agenda can be introduced by calling for a subsequent meeting. Now, Lordship, may I place the provisions of law in this respect? Now, Lordship, the Panchayat administration rules.
So why the second meeting is finalization and approval of Gram Panchayat plan and budget of the second half? And what was this is the same?
Yes.
For the same purpose?
Same purpose.
Yes, sir. For the same purpose?
Yes, in the first, because in the earlier meeting, the budget was not passed.
Can you come to that minutes of the meeting?
Yes, minutes of the meeting that for budget. But if your lordship kindly go through the English translation. Yes, the opposition members then presented their budget proposal through a vote.
Where from you are reading?
My lord, he has given the translated copy.
During discussion,
some members, including the opposition party leader,
yes,
expressed their opinion and objections regarding the budget.
Correct.
The members present in the meeting discussed the plan and budget proposal.
Correct.
The opposition members then presented their budget proposal through a vote by the members regarding this matter. They expressed their opinion against passing the budget.
Correct.
So no budget was passed. And unless
no, kindly come.
yes,
This
the names of those who oppose the passing the budget are listed below. All the members of the party decided not to sign. Since no further discussion was held, the chairman declared the meeting adjourned. So adjourned meeting can...
No, kindly. The
yes,
plan budget of the Gram Panchayat were approved by the majority of vote. Kindly come to the page 2.
Yes. The final plan and budget of the Gram Panchayat were approved by a majority vote.
Then?
My lord, how it is majority? 13.
That's why.
13 is not majority.
But you have taken, these are your decision.
But
this is your decision. You said that this is not the decision. I will pause
this is not by the Pradhan. And my lord, it is my lord the here it is the my lord the presiding officer is the not the Pradhan.
Who has conducted the meeting? Presided over by the Rafin Khatun,
Yes.
chairperson. Then kindly come to the proceedings of the meeting.
Yes. began the inquiry where the notice of the said meeting was properly issued.
Yes.
Chairperson thank all the members. It said the final plan budget of the Gram Panchayat yes, would be presented and approved. The chairperson presented the proposal for the discussion and approval. The detailed plans are recorded on the next page.
Where is the next page?
Next page.
There's nothing.
He has not given the next page.
There's nothing.
Lordship, the rules is the Pradhan places budget proposal and that has
First
been
paragraph is
discussed and
telling
this
that
is the
oppose.
My lord,
But the chairman declared the meeting adjourned. Now you're telling that the agenda of the discussion.
my lord,
final
if it is adjourned meeting, that it can be called again.
But it is your decision, sir.
My lord, decision of what? My lord, there is no
Finalization approval of the Gram
well,
Panchayat.
my lord, concluding decision is not there whether budget have been approved and it has been finally passed. So, my lord, the meeting can be held.
Where is your further notice? This
Further
was not-
notice that is under challenge.
No, I am telling this was not approved. Where it is? Where we found?
without the reason.
Where we found? Agenda for discussion, finalization approval of Gram Panchayat and budget of final proceeding of census begun and census also. All members present decided the plan of the budget of Gram Panchayat finance would be presented. The chairperson presented the proposal of the budget discussion and approve. Discussion and approval. Where is the detail?
Well, the details, my lord, the Pradhan is a necessary party.
That's correct, but where is you're appearing
My
for
lord,
the state? Where is
I am
the detail?
appearing the Pradhan. Pradhan is the my lord, body corporate and it is
Pradhan is not
under
made a
section.
party.
Pradhan has been made party.
Then
he has to come.
have you served the notice?
Notice is served.
He has to come. Pradhan is to give answer. What is the next part of the meeting? What is the next part of the resolution? What is whether it has been?
It is the budget result.
Budget means
the agenda itself, Lordship. Lordship, the normal general rules and law related to the meeting says.
This are P3. This P3.
Lordship.
Yes.
Correct. This is the P3.
Yes.
Page 32.
Yes.
Yes.
31 and 32.
31 and 32.
So kindly, what is the last paragraph? The same as the chairperson presented the proposal plan and budget for the discussion and approval. The details of the plan are recorded on the next page. This is recorded. Page 32. Read the second paragraph in the Bangla language. What is recorded?
পক্ষের সকল এইটা স্যার
Second paragraph.
পক্ষের সকল সদস্যগণ সহ পক্ষের রায় দিয়েছিলেন সই না পক্ষের they abstain from sign.
They abstain from signing, but equal 13 members.
No. What one before the signing of the chairperson, Pradhan?
Yes.
Correct. What is the last paragraph? What is the word?
কি আছে বড় ভালো করে
2025-28 FY এর জিপির ভর্তি পরিকল্পনা সংখ্যাতে অনুমোদিত হলো Lordship, this is known as 25-28 financial year. Then planning
That is not
is approved.
that is not the correct translated here.
correctly translated here.
Not the
And
correct-
the Pradhan is the answering body.
Tomorrow is the meeting.
But the Pradhan, unless the Pradhan man comes, Pradhan
I am staying the meeting. Let the Pradhan come and
yes
appear before the court and
My lord.
place all the record before the court.
yes
What can be done?
My lord, if it is the meeting is not held within 31st, the budget would not be passed for the years throughout the year.
That is the March.
No,
Uh,
no, 31st January. 31st
what
January
can
is
be
the last.
done? To come tomorrow?
My lord,
Bring all the-
Pradhan is
served upon him Lordship.
Pradhan, you are state
today is
under you.
20th. My lord,
To whom you are appearing? Against whom?
my lord, we shall inform through the OC so that Pradhan come. Let it be on 30th.
But meeting is tomorrow.
Let it be tomorrow. Tomorrow 10:30. We shall intimate the Pradhan through the officer in charge so that he may come.
So and so appearing for the
Produce কেন বলতে
petition.
ওল্ড রেকর্ডটা নিয়ে আসবে
So and so appearing for the state respondent.
Lordship, the secretary will
The
produce because
None
he's the
appears on
custodian.
behalf of the
প্রধান আসলে তো
none
সবকিছু
appears
নিয়ে
on
আসবে
behalf of You are appearing for the statement only one.
My lord, I am appearing on behalf of the, my lord, my lord, I am appearing on is 1, 2, 5, 6, 7, and 8.
So you are appearing in the Department of Panchayat.
No, Department of Panchayat, but Pradhan, kindly see 3 and 4.
Pradhan is under whom, sir?
Pradhan, no, it is body
Lordship,
corporate, section 4.5. It is
Lordship,
body,
may
it can be sold
I
and
submit
sold.
one thing,
It can
Lordship?
sold.
As per Rule 15 of the West Bengal Gram Panchayat Administration Rules 2004,
Yes.
it is the person responsible to record the minute. Is the proceedings of the minute meeting shall be recorded by the secretary of the Gram
So that is
Panchayat.
respondent number
And
3.
in this case, the respondent number 3 is
3
the
and 4.
custodian of the documents.
Yes. 3 and 4, my lord.
Now, so suffering for the petitioner. So suffering for the state respondent, that is respondent number 1, 2.
Mostly দরকার নেই আমি ভিডিওকে বলে
And 3 is represented by the state.
7 and 8.
No, 3 is only
None
represented.
appears on behalf of
Pradhan.
respondent number 3 and 4.
No. 3 cannot be represented. আরে প্রধান সেক্রেটারি হয় না কখনো সেক্রেটারি স্টেটে নয় না সেটা প্রধান এটা কাস্টোডিয়ান তো প্রধান
Dated 21st of January 2025. 21st of January 2025. Issued by the who has issued this?
The Pradhan.
No, this is issued by secretary.
Issued by the secretary.
No, secretary প্রধান হবে গো
P1.
Notice was issued by
P1.
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 P1 secretary, Lordship.
Issued by
P1.
the
Yes. P2 by 1.
where is the secretary party?
Yes, secretary.
The secretary is the party.
Yes, respondent number 3.
By name.
No. Jaisila Gram Panchayat
Issued by
service
the-
through its secretary.
Yeah.
It is
the
not
secretary.
properly made, but secretary has been made part.
Patala Gram Panchayat informing for convening the meeting on 29th of January 2025 at 12:30 p.m. at the Gram Panchayat office to discuss the agenda for finalization of and approval of Gram Panchayat's plan and budget for the second half of 25 of the year 25 and 25. Full stop. Counsel for the petitioner submitted that on 4th of January 2025, a notice was issued for conducting the meeting of finalization and approval of the Gram Panchayat's plan and budget for the second half 2025-26 on 9th of January 2025 at 2:30 on January 2025. Accordingly, on 9th of January 2025 at 2:30 p.m., a meeting was convened, but in the said meeting, out of 26 members, 36 members have given in favor of the budget.
13 members, they against.
13 members were against the budget and what
And
about the
13 members
they abstain from casting.
abstained.
13 members were abstained to participate in the said meeting. So nobody has given the consent.
Nobody has given the consent. That is why, my lord, here the dispute.
Accordingly, the meeting full stop.
No.
Consent. But in the proceedings dated 21st of January 2025, it was recorded that inward comma the chairperson presented the proposed plan and budget for discussion and approval full stop. The details of plan are recorded on the next page. But this court did not find any recording of the next page as mentioned in the minutes of meeting dated 21st of January 2025. Full stop. It is informed to this court, as per the notice dated 21st of January 2025, the secretary, issued by the secretary, again a meeting was convened on 21st of January 2025 for finalization approval of the Gram Panchayat plan and budget for the second half of 2025-26. Counsel for the petitioner contend that once the meeting has been held and that has been approved, That has not been
Not
approved.
that been approved.
My lord,
Proposal has not been approved.
Not been
proposal has not been approved.
not been approved, and as such, the Pradhan has no right to call for the second meeting for
The secretary.
the secretary has no right to call for a second meeting for approval of the budget.
And my contention is that it is adjourned meeting as the majority members has not passed.
Yes, sir.
My lord.
Court is dictating the order, or you come here and dictate.
That is not.
Full stop. The learned counsel for the state respondent submit that on 21st of January 2025, the budget was not approved. Accordingly, the secretary has issued notice for the second meeting on 29th of January 2025 for approval of the budget. Thus, there is no illegality for issuance of the said notice. Full stop. Consider the submission made by the counsel for the respective parties. This court find that in the proceedings of the meeting dated 21st of January 2025, in the last paragraph, it is mentioned that chairperson presented the proposal plan and budget for discussion and approval. Full stop. The details of the plan are recorded on the next page, but no next page is available with respect of the said meeting. Accordingly, this court is of the view in full stop. Neither the Pradhan nor the secretary of the Panchayat is appearing before this court in spite of service of notice. This court is of the view, before passing any further, this court is of the view, the total minutes of the meeting, the minutes of the meeting and the original minutes of the meeting has to be gone into minutes of the meeting dated 21st of January 2025 is to be gone into. Accordingly, the secretary as well as the Pradhan of what is the Panchayat name?
Meeting dated 9.
Jasaitala Gram Panchayat are directed to produce the original minutes of the meeting along with all notices dated 21st of January 2025 before this court on 29th of
meeting dated 9 January 2025.
21st of January.
21st January is the notice.
Second notice.
Second notice.
And the minutes of the meeting 21st of January.
No,
only.
minutes of the meeting dated 9 January.
21st of January. When the meeting was conducted?
9 January.
How?
Meeting was conducted on 9 January.
That does not disclose in the translation also.
It is translated.
You have listed 21st of January.
21st of January.
Read the 21st. Lordship, this is the notice was issued on that day.
Sir.
Notice cannot be put back onto the before the horse. 9th January. How it can be?
Again, this is also translated copies. You are wrong.
Wrong. 21st January is the date of notice and 9th is
Lordship, 21st January.
How it can be 9th January the meeting?
Of the meeting, all notices dated 9th of January 2025 before this court. Tomorrow at 29th January 2025 at 11:30 a.m. Full stop. Till the final full stop. The secretary and the Pradhan are restrained from conducting any meeting in terms of the notice dated 21st of January 2025.
4th January notice.
Or until further order.
4th January notice only.
Let the matter appear.
তুমি কোথায় লিখেছো এখানে
Until further order.
এখানে 9 তারিখের উল্লেখটা কোথায়?
Until further order. Let the matter appear tomorrow at.
এটা তো ভুল। এটা 29th হবে। এটা wrong.
At 11 a.m.
Wrong. এটা wrong.
11.
রেজলিউশনটা দেখুন না।
হ্যাঁ রেজলিউশন ঠিক আছে কিন্তু ওটা তোমার wrong.
In the meantime, Lordship,
Not to conduct any meeting, place all the resolution tomorrow, then I will decide.
Yes, my lord. Unless 29th, today is 20th.
Tomorrow is the 29th.
My lord.
Lordship, matter will appear tomorrow at
Tomorrow at 11.
11.
Yes.
Today is the 28th.
My lord.
Tomorrow is 29. 29 is the meeting. I state the meeting.
ভিডিও কে তো বলে
Let
দিচ্ছে।
let bring all the documents.
My lord.
The state respondents are directed
My lord.
The state respondents are directed to communicate the gist of this order to the secretary as well as the Pradhan for
My lord.
protection of the record.
But through the, my lord, the block development officer, that
You
will
take appropriate steps.
grateful, my lord.
Yes, next.
Number 2, for the petitioner.
Petitioner is working as a storekeeper.
Yes.
Who
Who is for the respondent? Sir, you are this letter, page 27.
Page 27.
Yes.
Page
Page 27 and page 30. Page 30 is the recruitment rule.
My lord.
Correct. Page 32, Roman 6. Promotion from amongst the head assistants selected on the basis of merit cum seniority. This is a recruitment rule for the post of superintendent, office superintendent.
My lord.
Correct, sir. Now
by,
kindly come
by
to the
promotion from among the head assistant.
head assistant. So this is the recruitment rule.
This is
Now
the
kindly come to the page 27. Clause 10. It is also issued by the governor, approval of the governor.
Yes. Yes.
To post of storekeeper and post of storekeeper and assistant accountant of the Jilla Parishad will be the feeder post of the promotion to the post of office superintendent Jilla Parishad.
Right.
So what is your answer to this?
Well, my answer to this is that if your lordship, I am grateful to your lordship, my lord. My lord, kindly come first to that, my lord, the recruitment rules. Recruitment rules at page number 30.
Correct.
Now, my lord, this is, my lord, by way of a gazette notification, it was
309.
published in terms of, my lord, section 224 of the Panchayat Act.
Correct.
That when a recruitment rules is, my lord, is framed, then that should be gazetted.
Correct.
Now, it was gazetted
Correct.
in terms of the, my lord, the Act.
Correct.
Now, my lord, kindly have a look. In exercise of power conferred by section 224 of the West Bengal Panchayat Act 73, the governor is pleased hereby to make, after previous publication, because whenever there is a, my lord knows that under the General Clauses Act, whenever there is a proposal that a rule or act is to be gazetted, then there should be a prior publication also. That is, my lord, as per General Clauses Act, section 21 or 22. Now, the previous publication as required by subsection was of section following rules that was, my lord, in 1997 rule. These rule, my lord, still subsist. I am coming to your lordship. Now, lordship, kindly come to that page number
27.
37.
27.
Yes. 27. Sorry, 27. Yes. Now, my lord, kindly come to page number 27. Now, page number 27 is a notification of 28th of March 2013. Now, my lord, this is neither gazetted nor the rule. Now, what is this? The governor is pleased to order that following promotion opportunities are hereby created in favor of the employees of 3-tier Panchayat Raj institutions in West Bengal. Then these are the, my lord, these are the opportunities.
Now in the
I'm
West,
coming.
just one question. Just answer to one question. Yeah, whether still in the West Bengal the 3-tier system is there?
Yes, yes.
Samiti is still there?
Yes. 3-tier system.
That is the Panchayat, Samiti and
Panchayat,
Parishad.
Samiti and Jilla Parishad. Now,
Okay.
this is, my lord, for Jilla Parishad.
Correct.
Now, my lord, kindly come to serial number 10. To post of storekeeper and accountant of Jilla Parishad will be the feeder post for promotion to post of office superintendent of Jilla Parishad. Now, this is, my lord, in terms of this, it appears that this is a suggestion or this is a, my lord, pre-revise of the rules and regulation. Now, let's kindly come to page number 28.
Yes.
Page number 28. After this, all this, my lord, the proposal, the governor is also pleased to order. Have you also got it, my lord?
Yes.
The relevant recruitment rules will be modified as soon as possible. So, in terms of this suggestion, the relevant recruitment rules, that is Rule 97, is required to be modified as soon as possible. And then the governor is also pleased to order that the promotion opportunities created by this notification will take effect from 1st April 2013. Now, very important. This rider is important. When implemented after revision of the relevant recruitment rules.
Yes.
Now, my answer is, my lord, as per my lord, the instruction, even of the today morning also, I instruction, there's recruitment rules has not yet been revised. These 2013, this, my lord, the suggestion by way of notification, not even gazetted, not even proposed to the, my lord, the cabinet, because before publication, this should be referred to cabinet. No decision has been taken. That 97 rule has not yet been modified or revised. So this has not been given effect to. This has not been given effect to. This is only, my lord, in the file. Now, my lord, kindly consider one thing, that unless it is, my lord, the gazetted in terms of the, my lord, also the as per General Clauses Act, unless it is being affected thereto, or being, but the effect being given thereto, then, my lord, the right, whatever it appears, no right accrues therefrom. So, my lord, whatever the answer given by the, my lord, the department in terms of the, my lord, letter, if you lordship kindly come to page number 48, because, my lord, in answer to the letter of the secretary of the Jila Parishad, my lord, additional secretary of the department replied to that there is no more any gray area right now. Lordship, kindly come to this, my lord, page 48.
Yes, I am there only.
Yes. In response to the subject under reference, I am directed to inform you that the process for extending promotion to the post of office superintendent of a Jila Parishad will be taken up as per West Bengal Panchayat recruitment and condition of appointment of employees of Jila Parishad Rules 97, byte number such and such, along with order number such and such of 7th March 2017. 7th March 2017 also annexed here too. This is, my lord, with regard to just, my lord, the modus operandi, how the selection process is to be continued. And
guideline.
Yes. Now, but so far, the, my lord, the who is to come within the zone of consideration, that is, my lord, as per the 97 rules. So my humble submission is this: no right still accrues on the basis of this, my lord, 2013 notification, which has neither gazetted nor on the basis of that the main, my lord, steps have been taken with regard to the revision of that rules. Unless and until it is revised, and revision, my lord, knows that, my lord, in terms of the, my lord, the General Clauses Act. If you lord say, kindly have a look.
No,
My
no,
lord,
no.
that is section
That is
21.
correct. That is
That
correct.
power to review, power to modify.
It is
in the
settled
same
law.
way.
It is settled law. If the notified recruitment rule is there, the executive order cannot be taken into consideration.
So this is all.
Yes.
Malad, the order that was passed, it is quite confusing to a employee, Malad, working in a Jila Parishad. Or should we
But
kindly
once the 2013 governor has given it
yes
direction, why you not file a writ petition taking a direction for notification or review of the recruitment?
That has not been done. That has not been done. That has not been done. That is not been done.
And in fact,
but that
now
order of the governor was passed, Malad, with concurrence of the finance department.
Correct. That's correct. This is the executive order. Executive order cannot prevail over the notified recruitment.
Of course, Malad, that is statutory rule. If they, I have also, Malad, in the morning I had a confusion about the effect of this particular order unless amendment comes into it. But what is the conduct of the respondents? Letters are written by the Jila Parishad to the secretary, additional secretary Uttar Dinajpur Jila Parishad, wanting them to explain what is the effect of 2013 notification. But nothing has been answered. And he has, also the authority is not sure as to what is the effect. Kindly come to page 52. It is from the secretary Jila Parishad to the senior deputy secretary Panchayat. Government is not coming forward with any answer. From the bar, it is stated what is the whether amendment has been done, why not done, what is the bar. It is a 1997 notification. Original. Kindly hold.
I'm representing the state, and my lord, there was
Kindly
no
hold.
occasion.
1997
After that letter, secretary Jila Parishad.
Please.
Why you are interrupting? Bad habit. 1997 notification published in the year 2009. Lordship has seen that. That was a notification of 1997. It was in the cold storage for so many years. Thereafter, 2009, my lord, it has been given a gazette notification, July 2, 2009. And after that, my lord, what is the effect of this, my lord, even also not known to the Jila Parishad. Jila Parishad has given a letter to the senior deputy secretary, page 50, 52. Senior deputy secretary does not answer to that. Deputy Secretary does not answer to that manner. I could have understood Jila Parishad stopped it.
But once the recruitment rule is there, how your right can approve on the basis of the executive?
Whether recruitment rule is amended or not amended, let it be disclosed by the Jila Parishad, through the Jila Parishad.
That they disclose, they will file their affidavit, but interim order cannot be.
But without prejudice, may I be allowed to sit for the written test? Let us come back 2 weeks else. Written test is held, my lord, here. But there is a notification of the governor. Governor's intention that this is a class which will be
That's
taken.
correct. Unless and until it is reviewed. Unless and until the recruitment rule is reviewed, how it can be taken into consideration as you are eligible for to participate in the written test for the post of office superintendent.
That was 2013 notification given by the governor's order, my lord.
You are the government servant. Government servant is the persons who are the eagle eye on all the papers of the administration.
No, I had an eye to the 2013. That's why I applied. No one has given any reply.
But you have not taken any steps after the 2013 for
the implementation of the amendment. Effect of amendment. Amendment. I was not there in the that particular time, my lord. Actually, I was in a feeder post
So
there.
why do you want to continue this writ petition, or can I dispose of this?
Well, I give a direction for affidavit. Short affidavit.
So and so appearing for the petitioner. So and so appearing for the state respondent. Full stop. The petitioner is working as a storekeeper in the Jila Parishad. Which Jila Parishad? Uttar Dinajpur. Full stop. Petition submitted. There is a post. One post of office superintendent in the Uttar Dinajpur Jila Parishad is lying vacant, and accordingly the Jila Parishad had notified the said post for filling of notified the filling of the said vacant post. Counsel for the petition submitted that by a notification dated 28th of March 2013, with the approval of the governor of the state of West Bengal, it is mentioned that two posts of
that should be it's still typing
the post of storekeeper and accountant of Jila Parishad will be feeder post for promotion to the post of office superintendent of Jila Parishad. Counsel for the petition submit that in spite the honorable governor of the state has approved that the storekeeper is the feeder post for the post of office superintendent, but the authorities are not allowing the petitioner to participate in the written examination for the post of office superintendent of Dinajpur Jila Parishad. He submit that when the authorities have notified the said post, the petitioner has time and again made representation to the authorities.
And authorities have also asked us
to the authorities to allow the petitioner to participate in the written examination in terms of the approval of the governor, in terms of the approval of the governor dated 28th of March 2013. But till date, the administration have failed to clarify whether the approval of the governor dated 28th of March 2013 is applicable to the petitioner or not. Per contra, an advocate appearing for the state respondent submits that and draw the attention of this court to the recruitment rule dated 20th May 1997, wherein the method of recruitment to the post of superintendent in the Jila Parishad is provided as follows, semicolon, by promotion amongst the head assistant selected on the basis of merit cum seniority, not comma close. Full stop. Learned counsel for the state respondent submits that though the governor has approved to consider the case of the storekeeper and accountant of Jila Parishad to be the feeder post of promotion to the post of office superintendent of Jila Parishad. But in the said order, it is also clarified that the said order will be implemented after revision of the relevant recruitment rules. He submit that the recruitment rule of 1997 has not been modified or amended till date. Still, the recruitment rule of 1997 is in force. And as per the recruitment rule of 1997, the petitioner is not eligible to participate in the process for promotion to the post of office superintendent. Consider the submission made by the counsel for the respective parties. Peruse the pleadings and the document. Admittedly, with the approval of the governor of the state, a notification has been issued on 28th of March 2013, wherein the storekeeper and the accountant of the Jilla Parishad have been made as a feeder post for promotion to the post of office superintendent of Jilla Parishad. But simultaneously in the said order, it has been clarified that the said order will be implemented after revision of the relevant recruitment rules. It is stated by the state respondent that the recruitment rule dated 20 May 1997 has not been modified or reviewed. And as such, as per the prevalent recruitment rule, the method of recruitment to the post of office superintendent is by promotion amongst the head assistants selected on the basis of the merit cum seniority. And the petitioner is not holding the post of head assistant, and as such, its candidature cannot be considered. Considering the above, this court did not find any prima facie case or balance of convenience in favor of the petitioner to grant any interim stay as prayed for the petitioner. Accordingly, the interim prayer is refused. Full stop. The defendants are the respondents are directed to file affidavit in opposition within 2 weeks.
2 weeks.
Reply if any.
2 weeks. I'm not available for 1 week, sir, or 6 weeks.
3 weeks. 3 weeks. Reply if any there to be filed within a week thereafter. List the matter before the appropriate bench.
And all states will be subject to result of the writ petition. Without that, they are taking 3 weeks. I shall be even reveal some. I might.
Rule, sir. If it is not a recruitment rule, then I could have been passed order.
I do not know. That is coming from the bar, my lord. No answer has been given.
You had disclosed the recruitment rule.
I have no copy of the.
Call the matter.
Well, subject to result of the writ petition. Ultimately, if I succeed, my lord, ultimately I hope that I will succeed.
That is always.
Always, if you succeed automatically.
As well, lord.
On your side, matter 6 at 12 note, and number 5 is a commercial.
Matter number 5.
I appear for the defendant number 1. I have an application GA2 under section 45 of the Arbitration and Conciliation Act.
Well, I appear for the respondent number 6. Your Lordship recalls that there's an order of the appeal court, and based on the order of the appeal court, there was peremptory direction for exchange of affidavits so far as we are concerned. So we filed our opposition pursuant to that. They have filed their reply. So my injunction, which I am suffering, that was required to be heard. In fact, that was being heard.
So
I'm for the defendant number 10. I'm for the defendant number 11 and 12, Your Lordship. Now, I have also filed my opposition. A reply has been made.
GA1 till my GA2 is either decided or not.
Your GA2 is 45.
GA2 is 45. I have a simple case, Malar. I'll take 5 minutes if your Lordship will decide what the.
Where is the GA5?
Mr. Bose is perhaps pressing for hearing of GA1.
Yes. No, I am pressing for hearing of GA1 because I'm suffering the injunction. There's an order of the appeal court. Based on that, I press for hearing.
If I will hear, if
Correct,
this court
correct.
find that automatically all will go.
Yes. No.
Yes.
All will not go because there's no arbitration
Yes.
agreement with the other defendants. At the highest, it will be only against
Yes.
Mr. Ghosh's client, which is 1 to 5. But against Mr. Bose and the rest of them, the suit.
So then Mr. Thakkar is suggesting that part of the suit will go, the remaining part will remain.
That is why Mr.
That
Ghosh
cannot-
will also
And
say.
the injunction shall remain.
That is not what I am suggesting. That is what Mr. Ghosh will
section
suggest.
Lord, in fact,
What
yeah,
the
of
appellate
course.
court says.
Kindly see what the
Lord, appeal court's order, my lord, kindly have a look at the appeal court's order. 20th of November.
trespasser.
I'll go. I'll just, if you don't let me move it, I'll just go.
My lord, counsel appearing for the defendant number 6, it was our appeal. It submitted that the defendants are aggrieved by the order, refuses to vacate the interim order, submitted that there is no privity of contract,
plaintiff and respondent numbers, defendant number 6, without adjudicating the said issue, the drastic interim order was passed, injuncting the defendant number 6 from operating the bank accounts to the extent of 18 crores. Mr. Thakkar, counsel appearing on behalf of the plaintiff, submits that the plaintiff, it has been categorically stated that there is a privity of contract with the plaintiff, defendant number 1, regard to supply of category of carbon such and such. Defendant number has received the entire consideration amount, but the goods have not been supplied to defendant number 6 and defendant number is in breach. There is no appeal preferred against the ad interim order of injunction at this stage. But there was like subsequently your lordship extended, so the original order of ex parte, we did not file an appeal from that. This is what the appeal court observes. At this stage, we are required to consider whether on the basis of the averments made in the plaint, an order of injunction could have been granted to the plaintiff. It is an admitted position that the present appellant did not file any application for vacating of the ad interim order on the returnable date. The ad interim order was passed on 10th May and is still subsisting. The said ad interim order is also not under challenge. It appears that oral prayer was made for vacating the ad interim order and was refused on the ground that the appellant had neither filed show cause nor had filed any application for variation of the interim order granted in the plaintiff. Learned judge felt that deciding the matter, affidavits are required. Prima facie, it seems that the plaintiff has not disclosed any document to show in writing that the defendant number 6 is assured to supply the required materials to the plaintiff through the defendant number 1. However, there is a pleading of such assurance held out by the defendant number 1 and 6 jointly and severally. In the absence of any documents covering the contract period, it needs to be assessed whether the defendant number 6 could be restrained to operate the bank account to the extent of 18 crores. Mere verbal assurance without anything else may not be sufficient to pass a drastic order in the nature of injunction at attachment unless it is supported by nature of dealings, transactions, and conduct. By reason of the order of injunction, the defendant 6 is unable to operate the bank account. Plaintiff is unable to show exchange of correspondence between the plaintiff and the defendant number 6, by which the D6, defendant number 6, can be held to be responsible for non-supply of defendant number 1 by the defendant number 1. If the defendant number 1 has received the money, it does not automatically follow that the defendant number 6 would be obliged to supply the materials to the plaintiff through the defendant number 1. However, it is alleged that the joint inspection had taken place at the warehouse of the defendant number 6 in performance of the contract. Unless a strong prima facie case is made out by which it can be said with some amount of certainty at the interlocutory stage that the defendant number 6 is also bound by the contract.
So only defendant number 6 has made the
Yes. It may be unfair to restrict the defendant number 6 for operating the bank account. Curiously, the defendant number 6 has not filed any affidavit nor any application stating on oath that such arrangement was not existing. But this was the mistake we made. The learned judge was proceeded on the basis of the averments made in the plaint and the injunction application and continued with the interim order passed. We do not find any reason to interfere with the order this way. However, having regard to the nature of the ad interim order, we would request the learned single judge to decide as to whether the ad interim order should be continued on the date fixed as against the defendant number 6 upon consideration of the pleadings to be filed by the parties in the meantime.
Yes.
So, based on these directions, I have an appeal court order, the other defendants don't. So, so far as my injunction...
Have you filed the affidavit?
Yes, absolutely.
Defendant number 10.
Within time...
In GA1 and yes.
So, based on the appeal court's order, my lord, if your lordship will see that internal page 4, the first paragraph where it ends, however, yes, my lord, it says that whether the ad interim order shall be continued in date as against the defendant number 6. Other defendants...
reply?
Yes.
Filed. They filed
All
the reply.
within time.
And what about the other defendant?
I have for the defendant number 10. The goods, my lord, was at my custody. I filed an application before the CMM for release of
What
the
has
goods. That
happened?
was the averment in the plaint.
Released?
No. This is the order they are showing.
Yes.
No, your lordship will take up GA1 perhaps if it commences to your lordship, my lord.
Date hai, koi fixed date hai.
8, except 8, 13 and 14, my lord, all the defendants have used an opposition to GA1. 8, 9, 13.
So I am fixing tomorrow at 3 p.m.
Very well.
Well, the demurrer
Very well.
application has to be heard first. Usually, if there's
But he has brought the appellate court order, then the defendant number 6 is to be then all the defendants.
Because I stand on a completely different footing altogether.
If the demurrer is heard, everything, the suit will go.
But other because that's then again the submission of Mr. How if they are not the party to the
That my
agreement.
learned friend will have to show, my lord, that it can be done in piecemeal. This
That
suit has
cannot
to be
be.
dismissed. I will have to be sent to arbitration. If it is
Okay,
found there are only 8 contracts, it's only between the defendant number 1 and the plaintiff. And then the arrangements have been made with other defendants, they have brought them in. So if my learned friend is suing them through me, they will also go to arbitration. Now it's very broad. But
Who is
nowhere
suing?
has he said that these contracts are null and void.
New opportunity.
So the plaintiff, it's the subject matter of the suit would be referred to
Now
arbitration.
Mr. Ghosh telling that you will be the party in the
Malad,
arbitration.
the only interest in
It's
in
going
this,
to be in
Malad, the seat of arbitration. Yeah, that's the only interest, seat of arbitration.
Roman holiday.
That's the only. Yeah.
By the parties.
Okay, so
Let's first get the injunction vacated, then Malad will think
345
about
B,
traveling
yeah.
to Rome.
345 B.
Alan?
Yeah. 345 B.
tomorrow at 3, I mean.
So, Malad, we'll proceed with 6. My injunction application, so far as is concerned, whether the injunction should be continued against the defendant number 6 or not.
Suit is fixed, my lord.
Very well.
GA1 will be heard, my lord, in the.
Okay,
GA1
I
will
will
be
take the GA1.
Yes.
Then
But your
because
lordship keep it.
keep
If
it
I am
and-
not there, your lordship will
yes, no problem.
And only one more thing, Malad. There, in my application, I find the plaint has not been annexed, though it's on the record. Because we were served with the injunction application.
Give the
So,
copy.
if we may use a supplementary, or
Writ of
I will
summons
hand
is
over
like
a
You're
copy
not.
of.
Yeah, hand over the
Yes,
copy.
very
No
well.
problem. So
Your
and
lordship
so
give me leave to rely on a copy of the plaint. Now we have got it.
so suffering for the plaintiff. Transition suffering for the defendant number 10. Transition suffering for the defendant number 1 and 11 and 12. Transition suffering for the defendant 14.
Take it.
Transition suffering for the defendant number 6 and 7. Mr. Boss, you are for the 6 or 7? 6 and 7?
6, only 6. Only 6. No, 6 and 7. Stand corrected, ma. 6 and 7. 6 and 7.
Full stop. Full stop. Due to paucity of time, hearing could not be taken place. Let the matter appear tomorrow at 3 p.m.
I'm told the ad interim order is expiring today, my lord. Let it be extended, please, my lord.
Till tomorrow 3 p.m.
Submit that. Can we submit that? The
Boss
interim
might
order
as well
granted
pass
here
the order.
is going to expire today and wait for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 10th of February 2025 or until further order, whichever is earliest. Give the name. Next.
Your Lordship, in this matter, you are for respondent number 3.
Well, I'm for the applicant, Pilot.
Item number 9.
9 and
9
10.
and 10.
Yes. What is the application?
Ship takes up the 10 first. Item number 10 is our application for restoration of my suit. And 9 blood is an application for condonation of delay in taking out the application.
10 is GA?
Blood
1.
GA4.
GA4.
GA4 is my application for restoration.
You are for the plaintiff.
I'm for the plaintiff.
You are for the
You are
defendant.
for respondent number 3.
There is a 30.
Mr. Shiva Mishan is online.
There is a delay of 30 days. I will begin with that. The delay of 30 days. The reason provided is that the learned advocate on record was not coming to court.
Where is the order?
Order in GA number 4. Lordship is taking GA number 4.
Yeah, GA number
The
4.
order of dismissal, my lord, is annexed at page 29. The 22nd November 2024.
What is the stage of the suit?
That I have inquired, my lord. The scrutiny was yet
Yes,
to
you
be
have not
completed.
taken any steps after
but
the
my lord,
scrutiny.
Yes, but my instruction and my lordship, before dismissal matter had appeared on many occasions. I only appeared. In the lordship kindly sees the cost title of the plaintiff, my lord. There are 37 defendants. My lord, amongst that, my lord, 31 defendants are my lord, fake Facebook and YouTube profiles. So, my lord, there was this problem of my lord, serving the summons. The department's view was that my lord, this kind of cost title, there has to be, my lord, because these are my lord, basically
But
online
you have
portals.
filed the suit in the 2022.
Yes.
2024, 2 years you have not cure the defects, what the court will do? What the court will do? What the department will do?
The defect is not in the form, but in the mechanism, which is a John Doe suit. That I am suing the people I don't know. So those defects. That here in this case, I'll be candid. The department should have also been a bit liberal, because the John Doe suit, I do not know whom I am suing.
So if it is so, you could have been filed the application before the court.
But
you have not taken any step before the court.
I have appeared on all days. I personally, I know I have appeared before this, before my lord, also before the other benches. When the matter was coming in the list, the matter did not come for some time. I also missed the track, and then the advocate on record also was not coming to court. That's my explanation. Was not coming to court at that point.
Yes, what is your objection, madam?
Your Lordship, just a humble submission to make. There was an order dated 15th July 2022, wherein Google LLC was completed in place of defendant number 1 and 2. Thereafter, the plaintiff was supposed to make consequential amendments to the plaint. That has not been done till date. There is an order of March 2023 as well, wherein it has been recorded that the plaintiff has to take steps. So that has not been done either yet.
I could not because of this.
So what is the submission? You want to file affidavit?
Your Lordship,
you're objecting for this application. What is the submission?
Yes, Your Lordship. The application is for Your Lordship to decide for restoration of the suit, but I just wanted to point out the plaintiff's conduct, because since 2022 he's not taken steps.
That is the problem, Mr. Tagupto.
I acknowledge, when I only undertake that, if Lordship that restores the suit and restores the interim.
What purpose should be served? You're not taking any steps.
I will take steps, because we are prepared to file an application.
What application?
Seeking directions from the court for expedition of the summons and everything, because there are 8 defendants which can be which could have be served. The defendants which are 5 defendants. But I can proceed against these 5. Rest are fake profiles of
So appearing for the plaintiff. So appearing for the defendant number 3.
So, Your Lordship, just to clarify, amended memo has not been filed. We had been impleaded in place of defendant number 1 and 2. So amended memo and amended plaint has not been filed.
So appearing for the defendant number 1 and 2. Counsel for the plaintiff, and the plaintiff has filed the present application, praying for recalling of the order dated 22nd of November 2024, wherein this court has dismissed CS-Com 364 of 2024 for default, along with all interlocutory application. Full stop. Counsel for the plaintiff submit that on the said date, counsel for the plaintiff submit that the petitioner was not aware. The plaintiff was not aware with regard to listing of the matter on the date fix. And as such, the advocate on record could not appear before this court, and accordingly this court has dismissed the suit. Counsel for the defendant submit that the plaintiff has filed the suit in the year 2022. Subsequent several orders have been passed, but in spite of the several orders, plaintiff has not taken any steps. It is also found from the record after filing of the suit, after filing of the suit, the defendant, the department during the scrutiny has found several defects, but the plaintiff has not cured the defects. Consider the submission made by the counsel for the plaintiff, counsel for the parties, and peruse the application. This court find that this court is of the view one opportunity should be given to the plaintiff to pursue the suit. Accordingly, order dated 22nd November 2024 is the recalled. Full stop. CS-Com 364 of 2024 along with GA1 of 2022 are restored in their original file. Full stop. GA1 is so GA4 of GA-Com 4 of 2024, 2025 is disposed of. Full stop. Department is directed to place CS-Com 364 of 2024 along with GA1 of 2022 before this court on 14th of February 2020.
Your Lordship, just two small clarifications. If you may also record that the plaintiff has to take steps for amendment of the plaint
Let that suit come, then I will pass. Let on
Thank
come.
you, Your Lordship.
One prayer, my lord. There was an interim order subsisting in my favor. My prayer be, my lord. But that interim order, my lord, unless Lordship specifically revives.
Come on that. Let the plaint
I
come.
was enjoying till the date of dismissal.
Come. That's why let that come on 14th. Let come on 14th.
Interim order, my lord, if suit is revived, my lord, kindly, my lord, restore the interim. Otherwise, my lord, it's against, my lord.
Next.
Obliged, Your Lordship.
Affidavit of services we kept in record. And the Lordship has also, my lord, probably not recorded the condonation of delay. There were 30 days delay.
Automatic.
I just indicate, my lord, that GA number 3 was there.
Affidavit of service kept in the record. Yes, call the matter.
Lordship,
My application, Lordship.
non-contentious matter.
उसमें क्या था दोनों है हाँ डिस्पोज
My application, non-contentious matter, all the affidavit of consents are there on record. The legal heirs are wife, one son, two daughters. All of them have given their
Where is the
no
will?
objection. Lordship, the will, your Lordship will find.
Page 12.
Lordship, it's dated 20th of March 2021.
Let junior be argue.
Very well, Lordship.
Where is the place? Your will, madam?
Will is at page 12, Lordship. Page 12 of the petition.
Page 12. I did not find any page 12.
Of the petition, Lordship, the main petition.
What is the name of the testator?
Vinay Kumar Saraogi, Lordship.
Vinay Kumar
Saraogi.
Sarogi. Where is the name of the executor in the will?
Page 13, Lordship, the last paragraph.
Saurabh
Saraogi.
Sarogi. He is the petitioner here?
He is the petitioner.
Yes. What is the date of the will?
Date of the will is 20th March 2021.
20th March 2021. To attesting witness. When the testator died?
23rd May 2021.
Where is the death certificate?
Page 18.
Page 18. 23rd March, May.
23rd May 2021.
Yes. Where is the legal heirs?
But all of them have given their consent.
Where you mentioned?
1st May 2024. All the affidavits are dated 1st May 24.
1st May 24.
24. Two daughters and the wife of the deceased.
Kalpana Sarogi. Gupta. Attesting witness. Who are the attesting witness?
Rajesh Jindal and Vijay Pratap Mishra, Lordship, they've also given their...
Both have given affidavit?
Both have given affidavit, Lordship. 1st May 2024, same day.
Since appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 20 March 2021 of the testator Vinay Kumar Sarogi. 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 The petitioner submits that the testator, while possessing good health and fit state of mind, has executed his last will and testament by appointing the petitioner as sole executor of his last will. In presence of two attesting witnesses. The testator died on 23rd of May 2021, leaving behind 4 legal heirs, that is, wife, son, and 2 daughters. The son is the executor and the petitioner before this court. All the legal heirs have filed their no objection for grant of probate to the petitioner. Two of the attesting witness, both the attesting witnesses have also filed their affidavit stating that the testator has executed his last will and testament in their presence while possessing good health and fit state of mind, by appointing the petitioner as sole executor of his last will and testament. Had the learned counsel for the petitioner peruse the original will, from a death certificate of the testator, from a affidavit of consent of all the legal heirs, and affidavit of the attesting witnesses. This court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate of the last will and testament dated 20 March 2021 on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. Copy of the will be made as part of the probate. Next, PLA disposed of. PLA number so disposed. None appears on behalf of none appears on behalf of the petitioner. The matter was listed on 2nd May 2024. On the said date also, none appears on behalf of the petitioner. Accordingly, this court passed an order to the matter go out of the list. Today also, when the matter is called, none appears on behalf of the petitioner, no accommodation is sought for. Considering the above, this court finds that the petitioner is not interested to proceed with the matter. Accordingly, PLA number 420 of 2021 is dismissed for default. Full stop. Interlocutory application, if any, also dismissed.
Lordship, I am appearing for the petitioner. This is an application for grant of probate of will dated 2nd May 2010 of the deceased, your Lordship.
Where is the will?
Lordship.
All formalities completed.
Lordship.
Where is the will?
Lordship, the will is at page 13. It's a registered.
What is the name of the testator?
Lordship, Kishori Bhat, testator.
Testatrix.
Testatrix. The Lordship, there are two, Nilesh R. Modi and Jyoti Bhatia.
No. Testatrix is the.
Oh, testatrix is Kishori Bhatia.
Kishori Bhatia.
Lordship.
Where is the name of the executrix? Executor or executrix?
Lordship, there are two. One is the executor and one is the executrix.
Where is the name?
Lordship.
The following persons have been executor, executrix. Nilesh R. Modi.
And Jyoti Bhatia.
Solicitor and advocate.
Lordship.
And Jyoti Bhatia.
Lordship.
Both are the petition before this court?
Yes, your Lordship.
Yes. What is the date of the will, madam?
Lordship, date of the will is 2nd of May 2010.
2nd May 2010. When the testatrix died?
She died on 23rd April 2020.
23rd April 2020. Where is the legal heirs?
Lordship, the legal heirs, there are 5 legal heirs, your Lordship.
Son, daughter, granddaughter, grandson.
Lordship.
What about the husband?
Lordship, he had predeceased the testatrix.
When he died?
Lordship.
What is the name of the husband of the testatrix?
Lordship, Ratan. Lordship, kindly give
Ratan
me.
Se Bhatia.
Lordship. Lalji alias Anand Ratan Se Bhatia. He predeceased his wife on 20th September 1999.
Yes. What about the attesting witnesses?
Lordship, there were 2 attesting witnesses. One had passed away in 2019 and there's an affidavit of the other attesting witness. Lordship, Pessi N. Dadina. Pessi N. Dadina is the name of the attesting witness.
What?
Pessi N. Dadina is the name of the attesting witness, Your Lordship.
Pessi and Adina. Yes. Consensus and suffering for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 2nd May 2010 of the testatrix Kishori What is the name? Kishori.
Kishori Bhatia.
Kindly see the will. Page 13.
Lordship, her full name was Kishori Bhatia. The death certificate also records Kishori Bhatia, Lordship.
Kishori alias Kishori Bhatia. Kishori Bhatia. Bhatia. Petitioner submit that the testatrix has executed her last will and testament while possessing good health and fit state of mind by appointing the petitioners as executor and executrix of her last will and testament in presence of two attesting witnesses. Petitioner says that the testatrix died on 20 April 2020. The husband of the testatrix was the predeceased who died on 20 September 1999. Counsel for the petitioner submitted the testatrix died leaving behind 4 legal heirs.
Lordship, 5 legal heirs.
5.
Page 4, Your Lordship.
5 legal heirs, that is son, daughter, 1 son, 2 daughter, and 1 granddaughter and 1 grandson. Counsel for the petitioner submitted all the legal heirs have given their consent for grant of probate. The petitioner submitted out of the 2 attesting witnesses, 1 attesting witness also passed away, and another attesting witness, namely Pessi, P-E-S-S-I, Pessi and Dadina, D-A-D-I-N-A, Dadina, has filed his affidavit stating that the testatrix has executed her last will and testament in his presence and in presence of the another attesting witness while possessing good health and fit state of mind by appointing the petitioners as executor and executrix of her last will and testament. But the learned counsel for the petitioner peruse the original will, death certificate of the testatrix, death certificate of the husband of the testatrix, affidavit of consent of all the legal heirs, and the affidavit of attesting witness. This court find that all the legal heirs have categorically stated that they have no objection for grant of probate to the petitioners, and the attesting witness in his affidavit has also categorically stated that the testatrix has executed her last will and testament in his presence of another attesting witness while possessing good health and fit state of mind by appointing the petitioners as executor and executrix. Considering the above, this court find that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate of the last will and testament on compliance of all formalities. At the time of grant of probate, the copy of the will be made as part of the probate. PLA number is disposed of.
Grateful, Your Lordship.
Next.
23, my lord. I appear for the defendant, my lord. I have personally not here, my lord. So if my lord kindly takes up next week, my lord.
I hope
This matter was already heard earlier also, not before your lordship, not before other way.
What?
Well, there are two amendment applications, my lord. I will humbly beseech your lordship to, if my lord kindly takes up next week, my lord.
So not very difficult, but can we just out of it? So that's hard. So how many times will my matter be hard?
So appearing for the print, appearing for the defendant, counsel for the defendant, place for adjournment on his accordingly it is adjourned. The matter appear on 11th February.
Deeply observed, my lord.
It will be next. What's my application? Yes.
Lordship, testatrix, and she died, Lordship, on.
All completed. Formality is completed.
She had no legal.
She has no legal. The publication was made. Citations were issued. So citation is to be issued. What about the husband?
Nothing, Lordship. She didn't marry. She was.
She
didn't marry.
Unmarried. So what about the brothers, sisters?
No one. They died long ago.
How it is possible? No one?
Lordship, she was living with her relative and.
And to whom who is the petitioner here? Who is the executor?
Lordship, the person with whom he was living, she was living.
So and so appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 9th of October 2019. Police counsel for the petitioner submit that the testatrix was unmarried and has no legal heir. Police considering the above, this court find that before passing any further order, citations is required to be issued. Let general and special citation be issued in terms of prayer B and C of the present application. Please, the petition is directed to take appropriate steps. Next.
Well, at item number 25, your lordship will find that there are two applications before your lordship apart from the probate application for grant of probate.
Yes.
Now, the first application which we had taken out was for discharge of caveat. And the second application on my advice, my lord, has been filed now, where I'm seeking conversion in terms of Order 35, Rule 28 of the original side rules. Conversion into suit from the probate application. So that's the nature of the application.
Who is the caveator?
The caveator is one of the sons, my lord, of the deceased.
Why discharge? Why it is to be discharged?
No, in fact, my prayer in this GA2 itself, your lordship will find, if your lordship looks into, in prayer C of the master summons, in view of the above orders, the application being GA1 arising out of PLA number such and such filed by the petitioner be disposed of as withdrawn. So I am not pressing that application any longer, GA1, and let there be a conversion order as per your lordship's.
They filed the affidavit.
Yes, they have filed their affidavit in support of caveat.
Where is the GA1? What is the prayer in the GA1?
GA1 prayer was for discharge of caveat.
So you are not pressing that?
Yes, I'm not pressing that.
Yes, anything?
Any additional, my lord, or additional written statement may be filed. Otherwise, my lord.
So there is no scope for any additional written
File the
statement.
affidavit caveat.
Affidavit, but
That will be
my lord,
treated
that
as
will be-
written
that
statement.
is
The
a
written statement. If
That
you
will be
wanted to,
treated
Yes,
do that.
yes, I'm filed the written statement, if you lord.
You all.
No.
That is be treated as a written
Written
statement.
statement, an additional written statement may be allowed. Otherwise, my lord, some documents are there.
So
And
those documents may be
Documents
placed.
you can
Yes,
disclose.
of course. Documents may be disclosed.
After the conversion in as a suit.
yes,
So it will become as a suit. Then
Yes.
I will pass an order for exchange of the inspection of the document. So what are the document you want? This is not the commercial suit. It's a
Yes.
normal suit.
normal.
Now you can disclose that.
Yes. Discovery inspection
Discovery
and usual
inspection and
orders and
affidavit of
framing
document
of
will file,
issues.
framing of issues and evidence will be.
And something, my lord, if you lord, my lord, required, my lord, if you lord.
What?
regarding
Lordship will not record anything. Lordship will go to the record which is available before the Lordship.
And all the standard issues which are there in case of
So
defense, those are all covered in the affidavit.
So appearing for the caveat of full stop. Consent for the petition submitted. The petitioner has filed an application being GA1 of
GA1 of
2014, 2024.
2024 for discharge of caveat. But now the petitioner intend to not press the said application. Accordingly, GA1 of 2024 is dismissed as not pressed. The petitioner has filed another application being GA2 of 2025, praying for
Prayer A, if your lordship looks into.
conversion of the present application being PLA 116 of 2023 to the testamentary suit, as the caveator has filed the affidavit in support caveat and affidavit in support of caveat. File the caveat and affidavit in support of caveat. Police considering the above, prayer A.
Prayer A and consequential prayer B.
Prayer A and prayer B of GA2 is allowed. Full stop. The department is directed to assign the number of testamentary suit within a week from date and to place before this court on 7th of February 2025. Full stop. GA2 is disposed of.
Grateful to
7th February.
Well, at 26, a big dapper for the applicant, my lord, your lordship can remembers that matter when an application for probate was filed before this honorable court, annexing a will which has been duly registered. But in course of delivery of the will, registered will, a computer sheet has not been served upon us. We, a doubt has been pointed out by the department that with the veracity of the will, we moved this honorable court, and by an order dated 1st of October 2024, the coordinate judge have directed the authorities of registering authorities to submit a report.
Have you filed the supplementary
Yes,
affidavit?
Supplementary affidavit,
What do you want to rely upon?
The certificate which has been issued by the registrar, that is at page 10. The Joint Commissioner of Revenue is the District Sub-Registrar Howrah. You have certified that the instrument of will bearing such and such was duly registered and is recorded in book number 3 in the office of the Joint Commissioner of Revenue and District Sub-Registrar on 20.
Yes, now what you want?
This part, the doubt, which has been pointed out by the department with the veracity of will, that is, I subject to what your lordships.
I think this is a best time that all the matters should be given to the department. The department will decide whether they are entitled.
My lord, and your lordship also pointed out with regard to attesting, affidavit of attesting.
You all persons are roaming around the department. What is to be done by the court now? They are suspicious upon the will. They are giving the direction, all this thing. What the court will do? You are sitting here. And after passing of the order, the court will not do, the department will not do anything.
Now, consequential, my lord, orders to be passed, my lord, for grant of probate. We have taken all necessary steps, and the affidavit of attesting witness is also filed.
Where is your affidavit?
Yes, my lord. At the time of filing,
all
yes, my lord,
have been completed.
Yes, my lord.
Formalities have been completed.
My lord.
Where is the will?
My lord, will is, my lord, annexed to the, my lord.
So what is the requirement of the certificate of the registrar?
My lord, that has been, my lord, pointed out by the department as because it's an incomplete. Even we have tried to persuade. Just think that this is an unregistered will. Even that sort of argument.
Achha, the number was not there in the register.
In that that last
book
sheet.
is not mentioned in the will.
My lord, last sheet.
Okay.
Last sheet.
Where is the will?
My lord, will is, my lord, annexed to the, my lord, petition. Your lordship kindly sees.
14th August 2020.
Yes, ma'am.
What is the name of the testatrix?
Aloklata Hazra.
Aloklata Hazra. Yes. Who is the testator? Testator, testatrix.
My testatrix.
Where is the name of the testatrix?
My lord, Aloklata Hazra, the first page.
Yes. On what about the executor? Executrix.
Executrix means one of the daughter.
Where is
Tultul
that?
Hazra Das.
Where is the name of that?
Well, at page 5 of the internal page 5 of the will. Lord, she said that I have 2 daughters, and with regard
Which
to
paragraph? Which paragraph?
yes, my lord.
Show me where is the name of the executrix?
My lord, just
Where? I could not find anything the name as executrix.
just give this moment. My lord, at
Come
page
ready.
7,
Huh?
my lord, internal page 7, my lord. Whereas I have nominated my daughter Tultul Hazra Das as the executor. My lord, page 7, my lord. The second, third paragraph, my lord. Whereas I have nominated my daughter Tultul Hazra Das as the executor of this my last will, and after my death, Tultul Hazra Das.
When she died?
My lord, she died, my lord. She died on 14th July 2022.
2022, yes. Where is the legal heirs?
My lord, legal heirs, my lord. I have stated at page 4, serial number 1 and 2, paragraph 5.
Daughter and both daughters?
2 daughters, both are daughters.
So what about the husband?
My lord, husband predeceased.
Where is that? Any death certificate?
Death certificate is not there.
No. Have you mentioned about the predeceased? Where you mentioned?
My lord, page 5, at paragraph 5, at the time of her death, left her 2 daughters as her legal heirs and who would have inherited as her husband predeceased her.
Yes. Where is the consent?
My lord, consent, my lord.
Consent of Babul Maji? Bulbul Maji?
Bulbul Maji, my lord. An affidavit, my lord, annexed to the my lord.
Who is the attesting witness?
Attesting witness, Bulbul Maji herself.
Huh?
She herself is one of the attesting witness.
Bulbul Maji. Where is her affidavit?
My lord, that affidavit, my lord.
Affidavit?
Yes, my lord.
She has stated anything?
Yes, my lord.
Where?
That is affirmed on 27th April 2023.
On 14th, along with myself and my husband, Arvinda Maji.
This is affirmed before this honorable court.
So and so appearing for the petitioner. The petitioner has filed the supplementary affidavit disclosing the document issued by the Joint Commissioner of Revenue and District Sub-Registrar Roman 2 Howrah, stating that, certifying that the instrument of wills bearing 48 of 2020 was duly registered in book number 3 in the Office of Joint Commissioner of Revenue and District Sub-Registrar Howrah on 24th of August 2020. Let the affidavit, supplementary affidavit be kept with the record. The petitioner has filed the present application for grant of probate of the last will and testament dated 14th August 2020 of the testatrix of the executrix Loklata Hazra. The petitioner submitted the testatrix executed her last will and testament while possessing good health and fit state of mind by appointing the petitioner as sole executrix of a last will in presence of 2 attesting witnesses. The testatrix died on 14th June 2022 and her husband was predeceased to the testatrix. Full stop. The testatrix died leaving behind 2 daughters. One is the petitioner herein, and another daughter, namely Bulbul Maji, who is also one of the attesting witness of the said will. The Another daughter, namely Bulbul Maji, has filed her affidavit stating that she has no objection for grant of probate, and she has also stated that the testatrix has executed her last will and testament in her presence while possessing good health and fit state of mind by appointing the petitioner as sole executrix of her last will and testament. Heard the counsel for the petitioner peruse the original will from a copy of the death certificate of the testatrix, from an affidavit of consent of the legal heir, and the affidavit as well as the affidavit of the attesting witness. This court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate of the last will and testament on compliance of all formalities. At the time of grant of probate, the copy of the will be made as part of the document, part of the probate. PLA number 158 of 2023 disposed of. Next.
My lord, I'm appearing for the caveatrix daughter.
In this matter, but we have prayed for return of certain ornaments which belong to the wife of the testator, Lord.
Yes.
And your lordship directed me to serve upon the wife, Lord. Lord, we have sent a notice, Lord, but that was received by the daughter-in-law, Lord. So I am not satisfied, Lord, with that.
My lord, we are against that. Those.
So, Lord, what I pray for, Lord, that I may be permitted to serve another notice, not upon the.
My lord, I have a suggestion. Myself, appearing for the caveatrix daughter. He is appearing for the
Testator. Sorry, Lord, the
wife of the testator is where?
Wife of the testator is there at her home, and she is very sick and does not have very coherent confusion. She is a bit confused. Sometimes she forgets whether she has signed any paper. There are many documents she has signed. She has no idea what she has signed. Many accounts which was in her name, all the monies has been transferred to this sorry, my lord. This is petitioner who is
not
the
correct.
Yes, that is correct. Who is the grandson, and we have non-confidence for such actions. For that reason, I suggest, my lord, if your lordship wishes that we both the lawyers can visit her, and we can hand over the ornaments to her. But
it is not mentally fit. What purpose would be by giving the gold ornament to her?
Yes, my lord. Next, coming to that point, because this is her Stridhan, so that may be kept in a separate locker, joint locker of the sister, means daughter, and the daughter-in-law, so that nobody says it is in her custody or his custody. For the time being, until she, the mother, says whom she wants to distribute, if she wants to distribute, that is her wish. That may be stated in front of all the family members. The caveatrix, she stays at USA. She wants to come very soon. Till then, things may be kept in such manner which does not affect anybody's interest.
Now, what about this locker is still there?
This locker is still there, but in the name of deceased testator, Pravir Kumar Rai. That may be
This locker was opened pursuant to the direction of this honorable.
But still the locker is there.
Still the locker is there.
The articles are lying in the locker itself.
What the court proposed, let the inventory is there, certificate is there, let the gold ornaments remain in the locker.
My lord.
Yes, my lord.
In the locker. And if in the meantime the wife comes before this court, file an application, ask for the release, there is no problem at all. If it is not, then at the time of filing, filing judgment, passing final and disposing of the suit, then it will be decided.
Lord, there is one point. These things are Stridhan. This
correct.
is not included in the asset of the testator.
That's correct. But at this stage, now it is the court property. Correct. It was in the locker. Now it is the court property. And that's why this court has asked to issue the notice This court has
Yes,
issued
the notice could not be served
could not be
properly.
served, and you are telling that the mental condition of the mother is not good.
Not good,
Not
not
good.
bad either, but not
bad.
good.
Correct, not good. So how the court can at this stage the gold ornaments can be given handing over?
No, that is not.
Whether she is in a capacity or not,
that's
at all,
telling.
give her consent, or
That
if
is
she
the
can-
problem.
That is not
she can
safe
distribute
also.
at all or not, that is also a problem, Lord. This is a practical problem.
So let the gold ornament remain in the locker.
And
Remain in the
the
locker.
LIC policies
Why
are
not
there, Lord.
regarding the LIC?
Those are also a problem, Lord, because
See, LIC will not lapse.
no, Lord, those are in the name of the testator, Lord.
Testator.
He has died, Lord.
Correct.
The
He is
nominees
the
are there,
nominee.
Lord.
He is
Unless
the
and if the nominee dies in the meantime, already one nominee has died, that is a son, Lord.
Correct.
Now that complication has already there.
becomes a part of all legal years.
And now, Lord, there are two other nominees, Lord. One is the wife of the testator, and another is the grandson, who is the petitioner before your Lordship, Lord. Now, if these nominees are also in the process, Lord, the further complication may arise, Lord.
So what?
My lord, I propose, my lord, with
At least
humble
the policies
proposal.
may be
The
discharged, Lord.
policies may be discharged, which is in the name of the wife and the grandson, but not the policy which is in the name of the son. He has
No, son, there is other complications, Lord. Let the son's policy remain as it is.
But even the policy that's why I'm telling at this stage the policy is released. How
this amount, whatever is the name of the wife, my lord, may be fixed for her running her day-to-day affairs. Also, I can hear they are saying, since she stays in the home, her home, where the daughter-in-law and the grandson also stays, and they look after her maids, whoever being looked after, they pay them. So I understand there are expenses which can be really borne by her own money, which her husband has left for her. So that may be done, my lord. That policy may be given to her and released in her name, and so that
That is
may
a
be
good gesture, Lord. That is a good
that may be fixed for her.
what is the amount of the LIC?
Amounts are not written here, I understand.
Why not? There might be.
Policy number and date of policy, etc. written. Sum assured. One is
Sum assured is 1 lakh.
1 lakh, but এটা অনেকগুলো আছে এইটাতে কিন্তু
How many policies are there?
Lord,
in the name of Shefali Roy.
Who is taking care of the mother now? She's alone.
The petition, no, the
Actually,
petitioner and her mother.
Who is the petitioner?
The petitioner is the grandson.
My lord,
Grandson has filed the
let me clarify, my lord. She is being looked after by the maids, and the money is being, there are enough money for her looking after, and the petitioner and the daughter-in-law stays in the same house, so they obviously have to take care some bit. Obviously, they are taking care. I am the daughter.
And you are the son.
Two
daughters
daughters are
are
there,
there.
not one son. Son predeceased.
One daughter.
And who is the testator? Executor?
There is no
There is no
executor.
executor, Lord. This is a letter of administration.
He did not name any executor, my lord, and the grandson has prayed for being appointed as executor, which we have objected, my lord. We have no confidence for him to run all the show.
Total seven LICs are there. Lord.
Total 9.
Total 9 out of 7. Out of that, 7 are in the
name.
Locker. In the locker.
Found in the locker.
7 are in the 7 nominees in the name of the
wife.
1 in the name of the grandson and 1 in the name of the son. Son predeceased.
So that lapse, that
And
nomination
this
lapse.
locker is the part of the affidavit of asset.
Yes.
Yeah.
Locker
No,
is
locker, no.
Affidavit of assets, but the
No, my lord.
but the total amount was not disclosed.
Locker is the affidavit of asset. Have you mentioned the affidavit of asset with regard to the locker?
Yes.
My lord,
the number was given. Two numbers were given, but the amount was unknown.
That's correct. That's why the court is allowed
Yes.
to open.
My lord, there was no mention
that
about
was
the
fine.
locker.
No. Affidavit of assets.
Affidavit of asset, there is a you have mentioned about the locker number. That's why the court has allowed you to open the locker and made inventory.
No, no, affidavit of assets আছে উইলেও আছে
So what is the dispute?
My lord, dispute is there are many amount that has been withdrawn without the consent of the daughters, which were in the name of the mother, and also amounts which were kept in the joint account with the daughter-in-law by the testator, that also withdrawn and kept in separate account.
1 page 6.
These amounts are heavy amount. We have asked them to disclose what amounts they have withdrawn from the mother's account, which they have not disclosed.
Where is the locker?
This page, bottom and next page, my lord, top.
Page 6, locker number 2 by 24 by 34, lying in Mankundu, State Bank of India, Mankundu. Amount not known. And another locker 72 by 2, lying at UCO
You
Bank.
got all these things from the UCO Bank.
Nay,
Yeah,
all this,
all
yes,
UCO
all this
Bank.
from
Because
UCO
State
Bank.
Bank only 100 rupees note.
100 rupees.
Yes. 100 rupees note. Nothing else.
So let it be remain in the locker. What can be done?
Only the LIC policies.
How? Let's see come how the court can allow, because there is a dispute. The allegation is that the son, the grandson is taking all the benefits. So today I will allow. Then again the grandson.
My
will
lord,
take
I
the
was
benefit.
humbly praying for a.
No, let all the gold ornaments and the LIC paper let remain in the locker. If the mother interested, let's see come and take file an application.
My lord, I was humbly submitting one. Let them disclose whatever amounts they have taken away from the mother's account, which was solely her senior citizen
Whatever
account.
it may be, madam, Ranjan. What can be done? What is the stage of the suit?
No, my lord, no citation was not issued.
Citation not issued.
No.
So now
I have only filed the,
fighting. Without the citation, you are fighting.
I have filed the caveat with affidavit.
How many legal years?
Yes.
Two daughters.
Two daughters.
Two daughters and one son who is predeceased.
None has who has come. You are.
I am for the one
of your
daughter and another daughter's
You are
husband is
appearing for
also.
whom? Sefali.
I am appearing.
Sefali is the wife.
Sefali is the wife.
She is not appearing.
No.
Give consent.
She has given consent.
Okay.
He has.
And there was the
obviously-
daughter-in-law. You are. What is your
I am
name?
appearing for Shomi.
Show me.
Sorry, Bulbul.
No name. is
Ranjita
Shomi.
De. Sorry, my lord. I
Ranjita
apologize.
Day.
I apologize.
Yes, Ranjita Day. And what about the other? Puspika?
And Pushpita, her husband is also present in court, and he has been given the power of attorney to appear on behalf of
We
Ranjita.
file wakalatnama
My lord.
on behalf of the Puspita. Pushpita.
Pushpita, I have not yet, because
That's
they will send the
And
citation.
Ritaman Roy, grandson. And the petitioner.
Riddhiman Roy is the petitioner.
And Debasri Roy, daughter-in-law.
Debashri Roy.
Already give consent. Give consent.
Consent.
They have filed this application.
No, only
Riddhiman
only
with
Riddhiman.
the consent of
So
Debashri.
now only these two daughters, whether the Puspita has filed the affidavit.
No, she is waiting for the citation, and I have filed, means Ranjita De has filed.
So and so appearing for the petitioner. So and so appearing for the cavitrix Ranjita Day. Full stop. Counsel for the petition submit that the wife and the wife has given her consent. Wife of the testator has given her consent. But the daughter-in-law, she's
consent.
Wife and the daughter-in-law of the testator has given the consent.
My lord, the wife means she has given consent when they have taken a signature. She doesn't know what signature they have taken.
Consent. Full stop. And there are other two legal heirs. That is two daughters. Out of two daughters, one daughter has already you filed the caveat. Have you filed the caveat?
Caveat and with affidavit.
One daughter, namely Ranjita Day, has already filed caveat and affidavit in support of caveat. But another daughter has not come forward, has no citations have been issued. Has no citations have been issued. In view of the above, let general and special citation be issued in terms of prayer A and B of the present application. The petition is directed to take appropriate steps. As regard the gold ornaments and the insurance policies which were located in the locker of the UCO Bank, let the same be kept and let the same remain in the said locker until further order. Next.
Much obliged.
28.
My lord, item number 28 is my application for grant of probate. Last time the Honorable Court was pleased to allow the amendment application which I had taken out because one of the properties was situated in Mumbai, for which we had said that we would be complying with the provision of section 283(3), and accordingly certain prayers were inducted in the originally constructed probate application. But now, my lord, I am relying upon your lordship's decision. Judgment are there, this is the judgment which your lordship has passed, and your lordship had only asked me to look into it. This is dated 6th of December 2024. In similar circumstances, internal page number 5 of your lordship's order in this matter, where your lordship had directed publication of the notice. So I'm pressing for prayer D of my amended probate application now, because all the natural heirs, they have given their consent, everything is done, other properties are within the jurisdiction, only 7 except one property which is in Mumbai. So let there be a paper publication in terms of prayer D of my amended probate application, madam.
What is the paper in the Mumbai?
My lord, that I don't know, but Times of India is having a wide circulation, and so does Sanmarg.
And in the
Hindi, Sanmarg is
Mumbai.
there.
Mumbai, there is no Sanmarg is there.
Sanmarg, I think, is there. It has a national publication.
So appearing for the petitioner. Counsel for the petitioner submitted one of the property mentioned in the affidavit of assets. Where is that property? Where is the details?
Affidavit of assets.
One of the property
is your lordship annexure F.
Affidavit of asset in schedule A 6 within bracket I, that is flat number 33, situated on the 6th floor of Meghdut Cooperative Housing Society Limited, comma, full stop, limited, comma, 95 dash capital B, comma, Marine Drive, comma, district Mumbai, comma, Maharashtra, 400002. 00002. Counsel for the petition submitted that as the property is situated outside the state of West Bengal and prayed for publication of gist of general citation in the English newspaper, The Times of India, and in the newspaper, Sanmarg, at Mumbai, for the information of any of the person who is having caveatable interest over the said property. In view of the submission made by the counsel for the petitioner, the petition is directed to publish the gist of general citation, publish the notice of the instant probate application with respect of the property mentioned above in English and in the newspaper at Mumbai within 2 weeks from date.
Yes, your lordship.
Within 2 weeks from date. Let the matter returnable within 4 weeks. This is the matter on 4th March.
Pilot in the
Publication 2 weeks, returnable 4 weeks. क्योंकि date लगेगा ना उसमें.
I was hoping if your lordship would be kind enough to direct the department in the meanwhile, if once it is complied, then they can issue the no
Department is
caveat
directed
certificate
to
after a particular time span.
directed to supply the what we can say, supply the gist of the notice which is to be published in the English newspaper and in the newspaper with respect to the sit case at Mumbai.
Right.
Format of the notice, format of the notice.
And my lord, so far as the no caveat certificate, if
Format
it
of
is
the
required,
notice.
then the no caveat
Let
certificate.
first publish, then
Very
we'll see to that.
Very well, I shall come back.
Next.
Smart, I appear for the petitioner. My application for grant of probate. My lord, the testatrix died on 8th of November 2017. The death certificate is at
Amendment
page...
is carried out.
Yes, my lord, that has been carried out.
Yes.
The death certificate is at
Where is
page...
the will?
Yes, my lord, the will is at page 14.
Who is the testator? Testatrix.
Page 13. Page 13.
Testatrix.
Testatrix.
Sharda Mehra.
Sharda Mehra.
Sharda Mehra.
Yes, my lord.
Yes.
The will starts from
what is
page
the name?
12.
Where is the name of the executor?
The name of the executor is at page 13.
Ashok Mehra.
Ashok Mehra, the only son.
Only son.
Only child.
When he died?
The deceased testatrix died on 8th of November 2017.
Where is the death certificate?
Annexure A, page 11.
Page 11. Sharda Mehra, 8/11/2017. What is the date of the will?
Date of the will is of 10th of August 2016.
Two witnesses. Yes. Where is the legal heirs?
The legal heirs, only one legal heir, that is at page para 5, page 6, page 3, page 6.
Only one legal heir.
Only one legal heir.
Ashok Mehra, he is the petitioner.
He is the petitioner.
So,
my lord, the
petition is made.
Yes, my lord. Grant of probate. The beneficiary is the wife of Ashok Mehra, the daughter-in-law of the testatrix.
Where is attesting witness?
The attesting witness, there are two attesting witnesses. One is Narayan Chandra Bishwas, whose affidavit of has been filed on 13th of December 2023. Subsequently, he died on 24th of May 2024. Thereafter, the other attesting witness, Shashibhushan Sinha, also affirmed, and that has been filed on 13th of August 2024.
So what about the husband of the testatrix?
Well, the husband of the testatrix died long back.
Very
It will appear from the death certificate itself.
Where you mention?
My lord, I have mentioned this in paragraph 5.
Yes.
Paragraph 5.
Appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 10th August 2016 of the testatrix Sharda 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 Mehra. Sharda Mehra. Counsel for the petitioner submit that the testatrix has executed her last will and testament while possessing good health and fit state of mind by appointing the petitioner as sole executor of her last will and testament in presence of two attesting witnesses. Counsel for the petitioner submitted the testatrix died on 8/11/2017 and the husband of the testatrix was the predeceased to the testatrix. The testatrix died leaving behind only one legal heir, who is the petitioner before this court. Who is the petitioner before this court? He submitted that the will was executed fully. Initially, one attesting witness has filed the affidavit, but during the pendency of the case, the attesting witness died, and subsequently another attesting witness, namely Shashibhushan Sinha, has filed his affidavit stating that the testatrix has executed her last will and testament in his presence and in presence of another attesting witness while possessing good health and fit state of mind by appointing the petitioner as sole executor. Consider the submission made by the counsel for the petitioner, peruse the original will, death certificate of the testatrix, and the affidavit of the attesting witness. This court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate of the last will and testament dated 10th August 2016 on compliance of all formalities. At the time of grant of probate, the copy of the will be made as part of the probate. PLA 488 of 2020 is disposed of.
Grateful, my lord.
May I be permitted to mention, my lord, item number 21, my lord?
Item number 21.
Yes, my lord. All proceeding complete, my lord. Kindly restore the matter, my lord.
Contentious matter, my lord, your lordship, while coming from that building.
Which one?
21, my lord.
21 dismissed.
My lord,
Kindly,
make
my
it,
lord.
not today, my lord.
Cancer
While-
patient, my lord. She is
And
not
it's a
coming, my lord.
non-contentious matter.
Non-contentious. Kindly, my lord.
On the
21.
not today.
Not
I-
today.
Not
Item
today.
number
Grateful, my lord.
item number 34 and 40, my lord.
Ah.
Our matter is ready and
It will come tomorrow.
financial.
Now 28 I reached. Tomorrow it will
I
come.
am also 33.
Kindly, my lord, I just one requesting, my lord, if it can be kept.
It will, yes.
That
See,
everything
one
is
day I am taking about 10 matters.
okay.
My
So
lord.
it will come.
Yes, kindly.
Grateful to your lordship.
Grateful, my lord.
Deeply obliged.
continuity in the matter previously. There was like
I'll try to
during
summarize.
short duration.
I'll try to summarize.
So what I was respectfully submitting, but before my learned friend starts, so may I just take 5 minutes, just recapitulate what I have said in just like point wise, bullet point. That's all, nothing. I don't want to go into the details since it's been a while.
I would be intending taking a one line argument by argument. Anyways, it'll be recapitulated because I'm trying to, I mean, my learned friend has taken about several days, no problem there. But I just trying to see if I can conclude by tomorrow. But so I'm trying to conclude, but it's also listed tomorrow. I'm trying to see if we can conclude by tomorrow because I have to cover arguments made over 5 to 6 dates. So that's why my learned friend wants to add anything in that.
So, no adding. What I said is, I will summarize what I have argued in 5 minutes. So, there will be a better, my learned friend will be in a better position to address the points. My lord, everything is based on facts. So, admitted, my lord, position, this present application is an application under Order 21, Rule 58, filed in an execution proceeding by a third party. My lord, the proceeding is between Augustus and Jagriti. One is a award holder, the other is the judgment debtor. So, the award has crystallized, execution filed, order passed in the execution from time to time. And in terms of the orders passed in the execution proceedings, certain money lying in the bank account were attached. Receivers appointed, receivers took the money, made over to us in put and to satisfaction of the decretal dues. Admitted position. So, not under those circumstances, we had made an argument that Order 21, Rule 58 is not available to them. Though those provisions we've shown of Order 20.
Use mine.
No. The point is that, my lord, I'll just, since I'm in a timeline, so like, so my lord, what I had specifically submitted, my lord, Order 21, Rule 58, if I may just trouble your lordship once. This was precisely our argument. My lord, this relates to objection to attachment of property.
Correct.
So today there is no further attachment.
Already there is an order.
So that attachment, if your lordship reads 58 with 55, now if your lordship will kindly see, it has to be read with 55. 58 read with 55 give rise to a situation that the objector, or here which can be the judgment debtor, can only object at the time when the attachment subsists. If an attachment does not subsist, 58 principles don't apply. Now, if your lordship will kindly take the proviso and A and B, which I had extensively submitted.
Yes, I take a note.
Yes, but entertained and all that. This was one part of my submission. So at the threshold, I say that his 2158 application is not maintainable on facts.
Correct.
Because admittedly, money taken, given to me in satisfaction of the decretal dues, there's no further attachment, continues. Now, my lord, the next point which we had argued was, my lord, the other points that he's trying to substantiate so far as fraud, this, that. My lord, your lordship recollects the suit. They had chosen to file a suit at the time when the attachment was subsisting.
Correct.
Rejection of plaintiff in the suit, single bench, then division bench. Now, division bench analyzed every cause of action in the suit and came to a conclusion, including the fact that what they are trying to say, that their right, is it the shareholders' right? They are the shareholders.
Correct.
So they say that the shareholders' right, considering Bacha Gazlar 63 moons, it has been held that your right is not on the asset. What you're trying to say, this amount which is lying in the bank account or whatever is there, this you don't have a right as a shareholder to say that. The management, and that it also deals with the other aspect, the appointment of director aspect. You say that this is the position in the company law and this is the best, or this is the right thing that could have been done, and that is exactly what has been done. So the division bench order, which was finally affirmed by the Supreme Court, well, now that operates as a res judicata. So that issue now cannot be reopened and re-agitated and re-adjudicated in a proceeding, in an execution proceeding by the same party and between the same party.
Because they are taking the liberty given by the Supreme Court.
No, that liberty does not if your lordship looks at that liberty that I had given you a judgment on liberty also.
Correct.
What was that?
No, that's what I'm telling. They are taking the plea of the liberty.
Correct.
They are
And
taking the plea of the
so the
liberty.
liberty has to be within the four corners of law.
Yes.
So if they are authorized in law, then that liberty would be of some relevance to them. They have filed the application. Now I have taken the demurrer point in the application. So, my lord, that liberty has to be construed. We've given one judgment to your lordship also that has to be construed within whether the application is maintainable or whether that liberty by itself does not, my lord, absolve me from taking the point of demurrer or the fact that the application is not maintainable. Now, this was primarily one of the points that we had argued.
Yes, let
Yes, very
let it finish.
Learned friend,
These are the threshold arguments.
Talk about threshold arguments. I mean, not only am I relying on liberty, the first court, civil court itself says we're not a court of competent jurisdiction. Res judicata, I'll come to that in a bit. But those are several points on res judicata which I want to point out. But before that, my learned friend has taken several dates and made several arguments which are premised on certain facts, which he says are admitted. With utmost respect to my learned friend, those facts are, he's not stated the complete facts. The property, he keeps saying it has been satisfied. On the last 3-4 days, he says the money, 28 crores, has been sold, nothing to come back. That is not the factual position. The money is still very much preserved by this court, the entire money. And I'll show how. My learned friend had handed over a copy of orders. Those orders are not complete. If I may just hand over a compilation of the court orders, I'll give it a copy to my learned friend.
I understand these are the additional orders apart from what I have already submitted.
No, these are I'm giving a comprehensive list because those orders which were given were selective.
If I may not create any confusion, I have given a set of orders. If I have missed out any order, let my learned friend give those orders which have been missed out.
Let me take the court through. I didn't interrupt my learned friend for 5 days. I've been listening. Let me argue my way. My learned friend has taken the court to Order 21, Rule 58. And he said there are certain threshold conditions as the provisos.
Yes.
First of all, there's judicial authority for the proposition that there are not threshold. Even that's a matter of evidence. I'll come to that. But let us see what is these proviso A. If I'll just read proviso A, where before the property is preferred, objection made, the property attached has already been sold. Now the court may just see the orders. The first order is of this Honorable Court of Justice Mukherjee, dated 10 June 2014, where the court records this is the amount to be due. The second order is of 26 June 2014, where my learned friend has read this. The receiver is appointed. From the attached account, so there was attachment, this amount had to be taken out and given in the SBI account in Calcutta. This is the second order. The third order is on page 4. If I may read, Justice Mukherjee, 10 July 2014, which says receiver will hand over this amount to Ascot by issuing the check. That is the JV. Ascot is the beneficiary, not my learned friend. And this was, the court was pleased to see, para 2, further interest payable by judgment debtor to Ascot Realty in terms of the ward in question from 1 May 2014
July
is 42 lakhs something.
Correct.
And again, there was to be another amount, another pay order in the favor of the receiver who had to take it. And with the clarification on the next page, it had to be given again to Ascot. Now, on the next date, this order, which my learned friend read, 15 July order, I'll read it again. Today, I'll read the third line. Today, Mr. Surajit Nath Mitra, learned senior advocate, appears claiming to represent 100% shareholder of the judgment debtor company, which is disputed by so-and-so, claiming to represent judgment debtor company. He wants to steer the operation of this order to enable his client to take out a substantive application. Considering the submissions made, I am of the opinion that the stay of the operation of order, if any, can be made only in a formal application. But to enable Mr. Mitra's client to do so, I direct the receiver to stay his hands from refraining to make any other sum or further sums collected by him pursuant to the order of this court for the time being. Then comes the 22nd July order, which says the application is ready for filing and the receiver will stay hand for another 2 weeks, the court may be pleased to see that the order is passed again by Justice Mukherjee. This is dated 22nd July. That's the date, instead of filing the application, the suit was filed. On the same day, the suit was filed on the civil side, impugning that arbitral award, as saying it's a product of fraud. Justice Mukherjee passes another order. Now,
that's why Mr. Bose's contention is that.
No, next order I'll take.
Yes.
I'll go straight, it goes to the suit, page 9. This is the order in the suit,
Yes.
passed by Justice Mukherjee on 30th July, and this order is very important.
Yes.
Page 12.
Yes.
Adjournment is paid on behalf of so-and-so, list the application of so-and-so. A very serious contention raised to Mr. Mitra, learned senior advocate regarding the execution of this award. To enable this court to consider the application of presence of parties, I direct continuance of my earlier orders to the receiver with regard to disbursement of funds in his hand. I also direct the beneficiary of the award to retain funds received by from receiver in his bank account.
Correct.
So as far as the 42 lakhs is concerned, that is very much with the receiver, deposited in court under the seizure of this honorable court. Regarding the money which has gone to Ascot was that money had to preserve its identity. It was not that they could withdraw it. This order simply says, I also direct the beneficiary of the award, that's Ascot.
I direct the beneficiary of the award
to retain any funds received by the receiver in his bank account. They could not disperse it, they could not withdraw it, subject to the orders of the court. That will come later.
Yeah.
Then comes the next order, which is passed in the execution, which on 12th of August 2014, page 13.
Yes.
The receiver shall create a short fixed term deposit of 42 lakhs in State Bank of India and shall keep the fixed deposit renewed from time to time until further orders. So this is until further orders. And there was a correct formal order on page 14. On page 15, the interim order shall continue until further orders. All this to show that the money has not been sold. It's not gone away. It's still been preserved by the honorable court. This is on page 15. Order date is 31st October 2014.
Since the demo application is being heard,
interim order passed shall continue till further orders.
Correct.
And then after that on page 16, the matter shall appear in the monthly list of June 2015. There shall be stay of execution of award.
Correct.
So that matter was stayed. So this is also relevant for proviso B, where I could have come to this court, and I'll show why I couldn't have come to this court. Page 17. The appeal was the execution application adjourned for 6 weeks with liberty to mention because by the time the appeal had been filed. So page 17 is that order that since appeal is pending and the claim the decree holder is secured, the hearing of this execution is adjourned for 6 weeks with liberty to mention in the event the appeal is disposed of in the meantime. Thereafter, there was the order passed in the suit on page 18. Or 15th May, which was sought to be modified by the order which is on page 19. This is in the suit. This is the order of 17th August 2015. And I won't trouble the court with the entire order, but just the on page 21, in the absence of any challenge to the award, the Honorable Court has it, page 21. In the absence of the challenge to the award, and having regard to the judgment dated 14 May 2015, I modify the award only to the extent that respondent number 2 as beneficiary shall retain the money subject to any orders that may be passed in the execution of the award. So this was continued. The award is modified to that extent. A typographical error on page 22. Then on page 23, since the appeal was pending, the execution was adjourned sine die. In view of the matter, learned advocate paying for the judgment debtor submits appeal is still pending, therefore prays for adjournment. In view of the same above, let this matter be adjourned sine die. With liberty to mention, I am the one who moved this application because as soon as the appeal got disposed of on page 24, on 9 January, the order where I moved this objections. And they were asked to file the reply. Thereafter, on page 25, we had filed the SLP. Stay was granted by the Supreme Court, which is on page 25, which is recorded. The Supreme Court, by order dated 24 January 2020, was pleased to stay the execution proceedings, and it went out of the list altogether. So my respectful submission, as far as the first proviso A is concerned, is that 42 lakhs is still very much here. As far as the amount handed over,
this is with the whom?
With the receiver who had to put it in the FDR with the State Bank of India under the control of this court. The court, this order, which I just read out on page 13. The receiver appointed by the court shall
Suresh Prasad Manjunath, so shall create a short-term fixed deposit of 40 with the State Bank of India main branch and shall the keep renewed from time to time until further.
So this money is still here. One learned friend keeps saying it's been satisfied, what is already has gone, can't come back, etc. The money is still here. And the money which is of 28 crores is the direction, subsisting direction.
Yes.
There is a subsisting direction that you're going to obtain the identity of the 28 crores.
Yes.
So this is factually incorrect. That the decree has been satisfied and nothing remains. On the contrary, there has been attachment and the money is still been preserved by this honorable court.
Yes.
Now, in a similar, the compilations or volume 1 had given in a similar case before the Honorable Supreme Court. Property had been put for auctions or sale, but the sale was not confirmed. Issue is, can you apply Order 21 Rule 58? And the Supreme Court said you can. That was a situation where the property had even been auctioned, but merely because the sale had to be confirmed. In this particular case, is still lying in the FDR, and there's the 20 crores identity has been preserved. So there's something further for the court to do, or for the order has to come.
Okay.
In that case, which is in that case is 2008-14 SSC 258. This is the citation, the first compilation I'd given.
Compilation. 2008, volume 14.
Yes, and the relevant part is on page 7.
Yes.
Para 12, after the court has extracted, and this is the identical argument what my learned friend is saying in para 11 has already been sold. Para 12, learned counsel points out that merely because the auction of the sold property cannot be said the property is sold, thereby leaving no right opportunity to the objector to object to the attachment. And then the learned counsel invited attention to judgment of the Andhra Pradesh High Court in so where a similar situation arose on the basis of application made by the appellant under Order 21 Rule 58 CPC. The objector was none else but the son of judgment debtor whose property was auctioned. The objection was that since there was a prior lease with respect to the property, and since in portion of that lease, the appellant objector had been in possession of the same, and therefore the attachment was not valid, had to be vacated. Objection was also raised the properties which were attached were already sold, and therefore the objection to attachment appeal become fructuous. The court therefore dealt with the effect of the court sale conducted by the low court. It was admitted position that before the said order of the High Court reached, the sale was already completed in respect of all the items where the decree holder himself purchased the property. It was also seen from the facts there that the sale was not confirmed. The division bench, speaking from Honorable Jagannath Rao J, as his lordship then was, observed in Paras 1. So, where a claim is preferred under Order 21, Rule 58 CPC against attachment moved properties, the fact that properties are sold or sale confirmed will not deprive the court of its jurisdiction to adjudicate on the claim. The inquiry into the claim can be proceeded with the trial court or the appellate court under the amended court, and in the event the claim of being allowed, the sale and confirmation sale shall to the extent be treated as a nullity and of no effect, as judgment had no title which could pay to the auction purchaser. So this was the law laid down, and the findings on para 16. On the basis of these two judgments, Learned Counsel urged that the objection application petition could not have been thrown away by trial court and the High Court as not being maintainable, considering the law laid on so and so. It must be held that mere holding of auction does not bar the objections thereto. In our counsel opinion, that in this case the sale was not confirmed, and that made a substantial difference. The word sold in clause A of proviso to Rule 58 has been read, meaning thereby a complete sale, including the confirmation of the auction, that not having taken place, it cannot be said that the objections of the appellant were ill-founded or untenable. And the court goes on in para 20 to explain this. And what is also relevant for our purposes, I won't read the entire judgment, just highlight the paras 20 and 21, but also relevant for our purposes, where the Supreme Court says that objections need to be adjudicated on merits. This is like a suit where the decree is appealable after the 1976 amendment. It's not summary procedure. All these arguments are doing as though it's a final argument. This is to be treated like a suit, and then the evidence has to be led. The court may see para 26. 26? Para 26 on page 13. Yes. It was urged before the High Court that the provisions of Order 21, Rule 58, read with provisions of Order 21 and Rule 101, spell out the duty of the court to adjudicate all questions relating to the parties, and that the Executive Court had failed to consider provisions in that perspective, and it should have decided as to whether the decree between the first and second respondent is a collusive decree merely meant to defeat the rights of the appellant herein, like in my case. The aforementioned proviso Rule 58, and more particularly Clause A thereof, was the only provision relied upon by the High Court, which is clear from the observations made in internal page 10 of the judgment of the High Court in the following words. We can skip that. We have already shown that this is not the situation of law. The High Court went further on to suggest that a merely agreement holder could not prevent the right of auction survey to get the sale confirmed. This statement is also patently incorrect statement of law. We have therefore no hesitation holding that the High Court and trial court were in utter error in relying on the proviso to Clause A of Rule 58(21). The appeal has therefore succeed. The executing court thus shall be obliged to decide the objections raised by the appellant. So this is the case for the proposition that what do you mean by sold? In this particular case, the money is still in the FDR under this court, and that identity has been preserved. That is sufficient to maintain my application. Now, case 3, which is in this compilation only, goes one step further. That is of Gopana. This is the judgment read by my learned friend himself. Correct. The court may be pleased to come to this judgment, which is on page 17. I'll just read the relevant part. So just one para. If I may just read para 9. My learned friend read this para 8 and para 9. But I'll just emphasize the last 3 lines of para 9. Even when an amount which is not with the judgment debtor is attached to execution, it is possible for one to invoke the provision. Even if the money has gone outside the account of the judgment debtor and put into the account of escort, I can still maintain Order 21 Rule 58. I can read this entire para 9. Yes. From the perusal of this, it becomes clear that the cause of action for a claimant to submit an application to this provision arises only if an item is attached on course of execution and not otherwise. Attachment can be of movable property or different categories under Rules 42 to 43, and the one of immovable property under Rule 54, Order 21 CPC. Rule 58 does not make any difference between movable and immovable properties. Throughout the length and breadth of the rule, the word attachment occurs in many places, hardly leaving any doubt that the sine qua non to invoke the provision of the existence of attachment. Even where an amount which is not with the judgment debtor is attached in execution, it is possible for one to invoke the provision. Here it was with judgment debtor. It was taken out under the orders of this court, given to the receiver, put in the handed over to the beneficiary. But that direction comes, you will maintain the identity. Oh. So as far as this proviso A is concerned, I have overcome this thing, though I do respectfully submit that this is not a threshold condition. This is a matter of trial. Case 7, which is in the same compilation, page 39, is the authority for the proposition that even for proviso A, you have to lead evidence.
Correct.
The court may be pleased to see page 39. And the relevant part is on page 40. It is
Yes.
It is a settled principle of law that the court, while determining the rights of parties under this provision, Order 21, Rule 58, can record evidence if it considers proper, seriously disputed question of fact, especially when they relate to court records, purchase of stamp paper, or a plea of fraud, should and ought to be normally determined after giving an opportunity to lead evidence. Under proviso to Rule 58 of the court, exception is carved out to say that in what cases the court can decline to entertain subjections. This proviso thus has been forced only in the limited cases which fall strictly within the ambit of scope of proviso. No doubt the scope of inquiry under this proviso is a narrow one, but certainly it is enough to properly adjudicate the claim of the objector whose rights accrued in the property prior to the passing of the order of attachment. Amendment of this provision by the amended Act of 1976 has been enlarged, and it is not to be governed by the earlier limited scope granted to the executing court by previous pronouncements. The attachment and termination of respective rights and execution was treated and actually dealt as investigation, the wider meaning and consequence. The Madras High Court in the case of so-and-so has held adjudication under the present Order 21, Rule 58 CPC is no longer summary, and it is the intention of the legislature that it should be a decision as if rendered in a regular suit, resulting in appealable decree. Fuller examination of the rights of parties have to be made after giving them adequate opportunity to place all relevant materials before the court. Para 7, the learned trial court has made some observations in the impugned order without detailed discussion on the subject, that the agreement to sell is exclusive one, and the agreement was entered only into only delay and defeat the execution of this decree. This finding of the learned trial court is without any basis, and in fact is without any affording any opportunity to the objector to satisfy the court on this behalf. The objector, as already noticed, was not given any chance to lead evidence. The objector who has filed the application with due explanation, even noticed by the trial court in the present case, was entitled to proper opportunity. The objector has the right to explain and satisfy the court that delay was not by design, and he approached the court without any inordinate delay. Para 10, the learned trial court also did not dismiss objections as not entertainable in accordance with provision Order 21 Rule 58(1), but kept the objection pending till 27/2/96 when they dismissed with the above observation. This view of the learned trial court is neither just nor proper in view of the settled principles of law and the inadequate reason given in the order. These proceedings in the given facts and circumstances of the case amount to the substitution of suit proceedings, and where the question of title interest is involved, proceedings have to be somewhat similar to that of the suit and cannot be permitted to be limited, and similar proceedings in the nature of the proceedings adopted by the trial court. So what my learned friend says that these are threshold conditions. These are not threshold conditions.
Yes.
Whether it is for attachment, whether it is for delay, I'm entitled to lead evidence.
Yes. Next.
Proviso B. According to him, his submission of the court will recall there has been a gap. I discovered this on 15 July 2014, and I filed objections in January 2021. I filed it actually on 26 December's affidavit. It was listed in 2021 January. And that's the reason there's been a delay. Now, Annexure 24 is 8/24 is a letter which I received from the bank informing me about this execution on the first time.
When you got the information?
That is on 10th of July 2014. The letter itself is dated 7th July 2014, page 162 of my objections. Now, that is when I got to know. I've taken the court through the order sheet. 15 July, I was in this court. 22nd July, I have had filed my suit.
Correct.
Orders had been passed by this court and in the suit, protecting me. If I've already gone to the suit to say this award is fraudulent, and I showed from the court, I'm entitled to have done both. There's no doctrine of election in this case. Where you challenge a decree on the ground of nullity, I can do it in collateral proceedings and number of proceedings I want to.
Correct.
So I went and filed the suit on 22nd July within 12 days. I appeared in this court within 5 days of knowing. I said, this is the position. Court was pleased to give me time to move the application. I filed the suit within 12 days of discovering. The suit was disposed of partially. Both sides went in appeal. My suit is the appeal is disposed of. Immediately after disposal of the appeal, I filed objections. In between, the execution itself had been stayed. There had been adjourned sine die.
Okay.
So in my respectful submission, there is no delay. My learned friend is just seeing the date of knowledge and date of filing. So the court will be pleased to see. I can take the court, flag those orders again, though I've read those orders.
Okay.
So not the decision for this proposition. I just read case 7. I would just like to read case 8 also for a minute. That is on page 44.
Page 44
of the same compilation. And the relevant part is on page 49. This is the decision of the Andhra Pradesh High Court. Relevant part is on page 49.
Yes.
From the wordings of proviso to Rule 58 or Order 21, it appears to me the court cannot dismiss the application as a belated one unless it gives an opportunity to petitioner to explain or satisfy the court that delay, if any, is not a designed or necessary one. In order to arrive at the conclusion, it is not enough for the court to merely look at the petition of the endorsement of return, endorsement of representation. The petitioner should be given an opportunity to show cause by producing some evidence or otherwise that he has not designedly, wantonly, or intentionally delayed filing the application under Order 21 Rule 58 CPC. He may explain and satisfy the court that it was a delay which was unavoidable and necessary in the circumstances in the case. In case the court intends to proceed under the proviso to Rule 58 Order 21, it is incumbent upon the court to not only give an opportunity to petitioner to satisfy the requirement, but also to indicate in its order that it has given sufficient opportunity and that it was satisfied that in spite of opportunity being given to petitioner, the application was designedly or unnecessarily delayed. Without following this procedure, the petition is merely dismissed on the ground that it is a belated one, and the order explicitly does not show that such an opportunity was given. It cannot be held that it's a proper disposal of the application under Order 21 Rule 58, and it would be a case where the court has failed to exercise jurisdiction or acted illegally over material irregularity in the exercise of its jurisdiction. It is no doubt true that in a case where there's alternative remedy by way of suitable party, this court should not ordinarily interfere with such order, but that's not the rule, and so on and so forth that goes on. The court may be pleased to see page 50, last para.
Yes.
Where the court has referred to other judgments if an application filed under Order 21 Rule 58 is disposed of in chambers without giving an opportunity to the petitioner to show cause why it is not designedly or unnecessarily delayed, a division bench of the Allahabad High Court in so-and-so case had held. But it seems to us the court cannot come to the conclusion whether there has been unnecessary delay without considering any explanation that might be offered on behalf of the objector. This cannot be known until the objector or his counsel have been heard and given an opportunity to explain the delay. We are of the opinion that in the absence of any opportunity having been given to the objector or the counsel to explain the delay, the court below acted with material irregularity in dismissing the objections, similarly on the supposed ground that there was an unnecessary delay. And we allow, according to law, this decision, revision, set aside the order the court below and send the case back to the court below to determine, after hearing the parties, whether there was an unnecessary delay or not, and if none, then to dispose of objections on merits. So again, for the proposition that in this case, in my respectful submission, there is no delay. I've been diligently prosecuting my remedy. The court, and I'll show when I come to constructive adjudicator why. Because in view of Sukanya, Dhulabai, why we went there in the civil side, why and what is the errors which was the High Court, which the division bench went in, and that was a summary disposal by the Supreme Court. Supreme Court has not approved the view of the division bench. The Supreme Court has summarily said we are not inclined to interfere, and the reason being, this was pending. This is a suit. So why do you need to?
But the Supreme Court says it not interfere. What is the meaning?
The meaning of that, I show the judgment, it simply says the Supreme Court did not approve. It does not mean the Supreme Court has approved the reasoning of the division bench. All it says is not inclined to grant special leave, and I'll take the court to those judgments. But that apart from the liberty, apart from that, the issue before the division bench, I'm being non-suited on 711. Facts or the questions of that
you cannot challenge it. Yes.
So what is assumed finality is that I can't file the civil suit.
Correct. You cannot challenge the award and the civil suit. That's
That's
the
all been
subject matter.
challenged. Whether there's been fraud or not has not been discussed. How can that be res judicata for this court? So I'll come to the res judicata separately. But now that is provided. So here I might straight away also cite, refer to the case cited by my learned friend, that is Barnes' case, which is actually in my favor. The court will be pleased to see what my learned friend has pointed out. In Barnes' case,
judgment.
This is 2001-7 SSC 94.
Okay. Which one?
This is 2001-7 SSC 94. Where
Yes.
my learned friend read para 19.
Yes.
That the attachment, there was interim relief, there was a modification of the attachment order by way of interim relief. But what my learned friend did not read para 17, we say that even if you want to modify the attachment order, you have to give a determination under clause 2, sub rule 2. The court may be pleased with para 17.
It is only upon determination of the question refer to rule.
The submission is that even if you want to modify, you have to give a hearing.
Correct.
So this, and this judgment does not say this has to be a threshold. It has to be only doing trial.
Without any determination of the question refer to sub rule 2, the question could not.
Now I'll quickly move on to the next point. Now the remedy, what my learned friend's argument was that the award is to be enforced as if it's a decree of a court. It's not a decree of a court. My learned friend relied on Vedanta, and that point I had some on the last day I pointed out that Vedanta's case my learned friend is relying on itself says that yes, it's not a decree of a court, it's to be treated as a decree of court for certain purposes like execution. And we are in execution. The court will be pleased to see, before I come to Vedanta, court, since we're on the compilation, court may be pleased to see whether this was my proper remedy. This is case number 9, which is on page 55.
Paralogist?
Tara Logitech. That is citation 2014 SCC Online Delhi 7528.
Yes.
In which case, in this particular case, the court will see on page 55, just first 2 lines, that these were petitions under section 34, challenging preferred against arbitral award. Next page, page 56, petitioner was admittedly not a party. So
yes,
like
you have pointed out, that are you taken note
pointed
of.
out. But para 12 is what I need to point out.
That is also, you have taken note
I've taken note. So the only remedy for me, my remedy by virtue of section 36 are to file these objections. I could not have gone to section 34 because I'm not a party. And in para 12, the court says you have to go under order 21 rule 58.
Yes, paragraph 13.
Paragraph 12, 13 and 14 first. 13 also. It thus follows that the question which the petitioner is seeking to be adjudicated for filing this petition under section 34 is the question, the mode adjudication whereof is by filing objections that are foreseen in the execution proceedings in which attachment has been ordered and not by way of filing petition under section 34. And that's what I've done.
Yeah, that's what you pointed out.
I had pointed this out earlier also. Now, if the court will see in this context, Vedanta's case, would the court like me to take the court through Vedanta's case, or because we had already argued that particular point? And even Patija's case, what my learned friend had argued, was on the issue that the award cannot be the basis of insolvency notice. That's not the situation here. None of these judgments are applicable, and my learned friend knows it. Because I pointed out, the court may just see the reply for a minute. Before the single bench, my learned friend argued that I have to file these executions. I've pointed that out earlier, but I'd like to again point it out in context of this argument. The learned single judgment in the suit is on page 38. This is their affidavit in opposition.
Affirm on 26 December. GA 39. GA 1.
A1 is a learned single judgment.
Page
38. The judgment starts.
Page 38.
And the relevant part is on page 48.
of this court,
of the judgment of the learned single judge this court. Partially
14th May.
14 May.
Which one? The partially has been
partially on page 48. Page 48 of the judgment in the second para.
Yeah, that I've taken note of.
Yes. So it is their case that you have to come. Now my learned friend is saying it's not maintainable. Now, in context of section 47, there is a very recent decision passed by the Honorable Supreme Court. If I may just hand that over. My learned friend to copy it. This is stated for the 2025 SCC online, Supreme Court 52. And the relevant part is paras 24 and 25.
Which 2025?
This is 2025.
State of Uttar Pradesh.
Yes. Page 7. We have made observations in the text of section 47 of the Civil Procedure Code 1908, which even at the stage of execution permits a party to object to the decree, both on the grounds of fraud as well as lack of subject matter jurisdiction. It is apparent that the arbitration proceedings were a mere sham and a fraud played upon by so-and-so by still appointing non-paying arbitrators who are passing part in valid rewards. To reiterate, response so-and-so not a signatory to appropriate arbitration agreement. Moreover, the party was so-and-so. Para 25. Accordingly, we law the present appeal and set aside the two ex-party awards dated so-and-so. Both awards shall be treated as null and void and non-enforceable in law. So it is open for me to raise the issue of fraud and lack of subject matter jurisdiction in execution. The reason why, and it is in this context to deal with what my learned friend has raised the argument. Hold on, give me a minute, I'll just take my notes out.
Yes.
On the issue of fraud and lack of subject matter for jurisdiction, my learned friend in the course of his arguments has made a categorical averment that there was a contractual liability to be pumping $5 million in the JV. That is factually incorrect. It is not in the JVs. There's no contractual liability in any of the two joint venture agreements.
That is a matter of fact. That fact is to be seen if it is going the evidence.
That is a matter of trial, which is the reason what I started by saying that we've spent 5, 6 hearings, 7, 8 hearings in this matter on the issue of whether this matter there's any threshold requirement, and that I've shown there's no threshold requirement. This matter in this routine ought to have been treated as though a suit matter should be listed for trial, where I would have established all these facts. But since my learned friend is saying that I cannot challenge, and I need to then satisfy the Honorable Court that fraud has been practiced, and not only fraud has been practiced, the award has been passed not on merits. It's been passed on admission. No, it's been passed on admission. Yes, there's liability. So the learned arbitrator has been misled to pass an award to say there's a liability of $5 million to be pumped in, when the subject matter, it's outside the terms of the contract itself. So there's lack of subject matter jurisdiction. So to that extent, I would need to take the court through even the cost of repetition since there's been a gap. Won't take much time, about 5-10 minutes, but summarize why I say there's fraud, why I say there's lack of subject matter jurisdiction, so as to make my execution petition maintainable.
Okay.
It is for that limited purpose. I don't intend taking the court through all the documents.
Yes.
But I'll just summarize what has happened. The court will be pleased to see, or the court may just see just 1 or 2 documents only. The court may be pleased to see my affidavit in reply to their affidavit in opposition.
Yes.
Page 155 of this. This, the court will recall, was approval letter given to the petitioner.
155.
155.
All right. Yes, you have shown that.
I've shown. This was the approval letter given to the petitioner.
Correct.
Which talked about the court is which talked about if the court will see that I'm supposed to bring in 10 million US dollars in paid up capital, which is para 4.
And
equity
participation.
And that's about it. And page 2, para 6, downstream investments was to be as per press note 9 of 1999. The construction development was to be as per press note number 2 of 2005. This is on page 156.
Page
156.
Yes, the construction development activities undertaken by the company as well as
the downstream delivery will be as a press note number 2 of 2005. It is in this press note 2 of 2005 that 5 million requirement is there. For those to whom that entire press note will be applicable, they would have to put 5 million. But that is not applicable to me. Only the nature of the construction development had to be governed by that press note. For the purpose of downstream investment, I had to be governed by press note 9 of 99, which is clause 1.
Yes.
In clause 1,
downstream investment shall be as per
press note 9 or 99.
Correct.
There is no requirement me to bring $5 million.
Yes.
The press note of 9 is on page 160.
161. Yes, you pointed.
I pointed that out. And the press note 2 is on page 158.
158, yes.
So reading this press note and the approval letters which is concerned, the position that emerges was that I had to bring in $10 million, which I did.
Yes.
There was no requirement from no statutory requirement for me to bring in the $5 million.
Yes.
This was not changed by the subsequent approval letter given to my subsidiary.
Yes.
Which is on page 162. The letter dated 7/2.
Further noted that new company in the style of Augustus Avani Land Developer has been incorporated to implement the project. Accordingly, the approval letter dated is above hereby transferred in the name of new company.
All the terms are the same. There was no change in terms apart from the license being transferred from me to my subsidiary. The court will see the joint venture agreement with the subsidiary, which is on page 109.
Page 109.
9. That is the JV agreement.
Yes.
109.
Yes.
This is between Augustus and Jagrati. The court may be pleased to turn to page 111 in the recital clause 3. That Augustus is a company fully owned and controlled by Starlight Real Estate. My learned friend says I'm a third party.
Yes.
It's my subsidiary.
Yes.
Wholly owned. I bring the money in.
Yes.
So there's no requirement. There is no requirement in this, the JV is a contract. There's no requirement in this JV of 5 million.
Okay.
So there's no statutory, that's anywhere between me and the government, whether to bring 5 million or not. Nothing to, it's not a matter of contract, nothing to do with them. But that apart, there's no statutory requirement, there's no contractual requirement. And yet the court will see how fraud is practiced. Court will be pleased to see page 172. What my learned friend had read this argument, that fraud, if any, but your own directors, nothing to do with us. Page 172, the letters triggered off by Jagrati, my learned friend's clients, to the RBI, saying that 5 million have to be put in.
Suitable order directing infusion of funds as per the press note.
No, 2005. They go on press note 2, which is not applicable to me. They cite the press note and they tell the RBI, please tell them to put 5 million. That is, which comes in the infused funds on page 175 is the requirement where they say, please tell them to infuse funds. If I may just read just one para relief sought.
I request you to issue the appropriate order directing the APDL to
infuse $5 million.
Correct.
Where there's no statutory liability, there's no contractual liability. The persons masquerading as directors or respondent, who we have managed to now get removed, write a letter to the RBI, which is on page 170, says yes, we have to pay 5 million. This is where they suffer a collusive award later on, eventually. This is page 170.
So 172 written by whom?
By Jagrati, Sharda Group.
Where it is? Who has signed?
Jagrati, on page 172 itself, Jagrati Trade Services Limited.
Jagrati, yes.
They write a letter to the RBI.
Correct.
Saying that please tell them to infuse 5 million.
Correct. And 170.
And 170 is letter written by Augusta saying, yes, we have to give them 5 million. And for that, we've issued these 2 checks.
So you mean to say the Jagrati
and Augusta's directors colluded to take away my money?
In connivance.
In connivance. They practice fraud. Now, these 2 checks which were issued, in the meantime, I had frozen the bank account. The court will recall.
Correct.
These were dishonored. They went to the Bombay High Court against the RBI saying they should be encashed. Bombay High Court said it pleaded us, you should notice to us in Mauritius. We appeared, we stated the facts. The Bombay High Court dismissed the petition.
When?
Those dates are there. I'll take the court directly to those orders.
When the Bombay Court heard.
I'll give the thing. If I miss that.
And when you came to know about these letters?
No, I got to know all this subsequent after.
That's why. That's when you came to know all this.
Of this particular letter, much after 2014. But I can find the exact date. But it was only when we discovered this fraud being practiced after.
That's why where we have disclosed, you came to know about this fraud. Which date?
That I'll just.
Where is your pleading on that?
I'll just come back to that. I'll just come back to it. I'll make a note. I'll come back to that.
Correct.
But if the court, what I have taken the liberty of doing, because I wanted to, there are orders of which I placed for today, and I'm also going to place on record the NCLT orders as to what has transpired there, because hearings have been going on there. I've taken the liberty to make this comprehensive list of dates. If I may just give this, I'll give a copy to my learned friend, which has sequence-wise what happened on which date. If I'll just take the code through that, and I'll give a copy to my learned friend. Yeah, just one second. The court wanted to know, I'll just point out, the court will come straight to page 7 of this, where I've documented how this happened. On page 7, item 24.
Yes.
Since the HSBC did not honor the 2 checks for 15 crores and 5 crores, the 4 named 3 individuals filed with petitions in the Honorable Bombay High Court. This is Naksha 18. Supposed on behalf of the respondent themselves against the RBI and the HSBC seeking interior honoring of the aforesaid checks. Applicants were not made party to the strict petition, were unaware of the same. The Honorable Bombay High Court, dated by so-and-so, were pleased to issue direct impleadment. The Bombay High Court dismissed this petition on 4th of January. The review was dismissed on 29th of March 2012. Supreme Court dismissed the SLP on 2nd July 2012. All those orders have been annexed.
Correct.
Now, after they failed, just to complete the narrative, after they failed to get this thing cashed, they invoked the arbitral clause in this joint venture, which this joint venture I was just reading on page 2.
Yes, page 109.
Yes. They invoked the arbitration clause in that to suffer the exclusive award. The court will be pleased to see.
This agreement is this joint venture is 2007.
Yes. So after they failed to do this, the court will be pleased to see the arbitral clause in this particular. I'll just go to the relevant part, to the arbitral provisions. It will give me just 1 minute. I'll just.
Seven.
137. 137, para 16. Court may be pleased to see this. After they were not able to encash 20 crores there, in the event a dispute arises between the parties during the subsistence of this agreement, and thereafter in connection with the validity of this, interpretation implementation of the alleged breach of any provisional agreement, the parties will try to do a friendly consultation or refer the matter to arbitration. Clause 16.2, all disputes, differences, and questions whatsoever arising either during the continuance of this agreement or afterwards between the parties hereto and their respective representatives touching these presents or the construction or application thereof, or to any act, deed, or mission or any of the parties hereto in any way relating to these presents shall refer to the sole arbitrator to be appointed as per ICC rules of arbitration. In the case the parties
Agreed upon the one or otherwise
three arbitrators, such arbitration shall be held in Singapore and shall be in accordance with the said arbitration rules of the ICC. What they do is, Jagrati writes a letter to Augustus. Let's shift it from Singapore to Calcutta. Appoint Mr. Honorable Justice so-and-so as arbitrator. The consent comes within 3 days. Before the arbitrator, Augustus says, yes, I have to pay 5 million. A award comes out. This is recorded in the award itself. The court will please to see the award. So this is the way the fraud has been practiced. First, they try to do it by getting the checks issued, which we block because the accounts are frozen. Then they invoke this arbitration clause. This is invoked around 2 or 3 months after the dismissal of the writ petition by the Bombay High Court. So if you see the court will see the dates. The High Court dismisses it on 4th of January 2012. The arbitration is invoked on 13th of March 2012. This is for point 26 on my list of dates.
Yes.
Both joint ventures provided for appointment of the sole arbitrator as per the ICC rules of arbitration, and that arbitration shall be held at Singapore in accordance with the arbitration rules of the ICC. Shortly after dismissal of petition number so-and-so by the Honorable Bombay High Court, the petitioner vide his letter dated so-and-so, that is 13 March 2012, now proudly invoked the arbitral clause in the joint venture agreement dated 12/7/2007 while seeking arbitration in India instead of Singapore as stipulated. The respondent unsurprisingly and conclusively agreed by this letter dated 17th March 2012 within 4 days. It is supposed to be, there's a genuine dispute, people are not going to be that cooperative. What is very important to note also, which I point out here from the record, the address of Jagrati, address of Ascot JV, and the address of the director Iraj is 12 Shakespeare Road in Calcutta. Same address. I'll show that. That also comes out. Significantly, it was a petitioner who proposed the name of the learned arbitrator who has passed impugned order dated so-and-so in Calcutta has been recorded in the award itself. And then, of course, I go on to say there's no contractual obligation. So there's no contractual provision either of the joint venture imposing a liability on respondent pay 20 crores to Ascot, nor any requirement of the approval letter dated so-and-so or dated so-and-so do so. The respondent, presumably through the persons masquerading as director of the respondent, supposedly admitted the fraudulent claim of the petition in arbitration proceedings to effect there was such liability. The award dated so-and-so, which was thus collusively and fraudulently procured by the petitioner, accordingly holds that the respondent has admitted his liability of investing the said sum of rupees 20 crores and directs such payment with interest in favor of Ascot. The petitioner and the respondent thus misled the learned arbitrator into traveling beyond the terms of the contract joint venture agreement and to, in effect, arbitrate upon a non-existent compliance requirement of the applicant's qua the government. the learned arbitrator simply no jurisdiction to do so. The award is also vitiated for lack of subject matter jurisdiction.
Yes.
So this is how the fraud, and then of course, to come back to the narrative, all of them, if the court will see the execution petition and the award, all of them have the same address. Court will see the execution petition and the award. Jagriti is the course title itself. 3A Shakespeare Sarani, Calcutta.
Yes.
The JV address is given, unfortunately this is not numbered, but in para 4I is the way they give the address of Ascot. No, not I, sorry, H, I'm so sorry. H, the last 3 lines, joint venture at so-and-so, 3A Shakespeare Surani, and then it's admitted position before the Supreme Court in all the matters. Neeraj Kumar Pandey, the director, has the same address. That's in the SLP itself.
Okay.
So this is the kind of fraud which has been practiced upon. It is for this reason the court may be pleased to see what the Supreme Court has said. I'll just deal with one judgment in the from the compilations.
Okay, come tomorrow. 3 p.m.
Very well.
Sense offering for the decree holder, sense offering for the objector. Counsel for the objector has argued at length, but due to paucity of time, hearing could not be completed. It is fine from the record. The matter is already fixed tomorrow at 2 p.m. Tomorrow at 2 p.m. Let the matter appear on 29th January at 2 p.m.
Right.
That I had relied on those decisions of the Supreme Court.
Yes.
Amendment, my lord. My lord, may I just show the arbitration clause, which encompasses even an invocation of the bank guarantee. Lord, if your lordship is kind enough to take volume 1 of the petition at page 42.
Petition,
my lord. Volume 1 of the petition. IAGA number 1.
Yes.
Your lordship kindly takes clause 17.2. If any dispute, clause 17.1 says courts in Calcutta will have jurisdiction. If any dispute or difference of any kind whatsoever shall arise between the parties in connection with or arising out of this contract, and whether before or after termination or breach of this contract, parties shall and in good faith negotiate and with a view to its amicable resolution and settlement. The aggrieved party shall provide a written notice to the other party stating clearly mentioning the specific reasons of dispute, and shall provide the other party a reasonable time period of at least 15 days to address and resolve before initiating any other action, such as seeking as legal remedies encashment of bank guarantee. Now, my lord, next page. However, if an amicable settlement cannot be reached, the same shall be referred to a sole arbitrator to be appointed by the parties mutually. In the event the parties are not able to agree on the sole arbitrator, then 3 arbitrators. So, my lord, even encashment of bank guarantee is the subject matter of the arbitration agreement between the parties.
Yes.
Now, if your lordship kindly takes their AP, which is at page 171 of volume 2. Sorry for troubling your lordship with the papers, my lord.
No problem. 171.
171.
Yes.
This is the application under section 9.
Yes.
My lord will kindly see the cost title. Just the respondents have been, number has been Ellenbury, that's the plaintiff petitioner. Bengal Energy, that's my client. And my lord will kindly see the bank is also a party. Now, there is no difference between section 9 and section 70. Now, my lord will kindly see the prayers, which is at page 207. I was the respondent number 1 there.
Yes.
So, pro forma respondent, no relief is sought for against the bank. And that is carried forward in section 17. There is no separate section 17 application made. So, when do I make a pro forma respondent? When I don't seek any relief against that party. My lord, prayer A, direction and or order upon the respondent number 1 company to forthwith make over the original performance bank guarantee dated 13 June 2023 amounting to such and such, and the performance guarantee number such and such amounting to such and such to the petitioner, to enable the petitioner to forthwith have the same cancelled by the respondent number 2 pro forma respondent. Relief is against me. An order direction upon the respondent to forthwith
Enable
return.
the petitioner to forthwith have same cancelled.
To enable the petitioner to have the same cancelled by the respondent bank. The original is with me, I will have to produce it. An order of injunction upon the respondent to forthwith return the performance bank guarantee such and such. Then prayer C. An order of injunction, that is what has been passed in section 9. He passed restraining the respondent number 1 company from invoking the performance guarantee dated such and such, amounting to such and such. So prayers against me. Why couldn't he have agitated this before the arbitrator? Because after amendment.
So you mean to say, if he filed an application under section 17, he can pray for the same relief before the arbitrator?
Yes.
Against you also?
Yes, yes. Against me, because it's his primary relief is against me. Now, my lord kindly looks at the orders. Now, I'm sorry, my lord. Before that, I would, no, that would be what a merit se jao. What I need to put. Now, my lord will kindly see the orders which were passed. My lord, first is the order dated 19 July 2021.
Yes.
My lord, they invoke the arbitration clause by a notice dated 17th of July 2024. Your lordship can make a reference, that's at page 166 of volume 2. This is their notice under section 21 invoking the arbitration agreement. I'm sorry, my lord. I'm sorry, the page number 158. I'm sorry. 161 is my response. At page 160, your lordship will find notice for commencing arbitration under clause 17.2, which I have just shown to your lordship. And notice under section 21.
Yes.
Now, your lordship kindly takes paragraph 14 of that notice. That is the subject matter of arbitration. In the backdrop of the above mentioned fact, EIGL, that is Mr. Chaudhary's client, called upon BL, that is my client, by its notice dated 20th June to immediately return the 2 performance guarantee given by EIGL to BEL as the performance of the said agreement stood successfully completed. EIGL has given notice of dispute under 17.2 and BEL to resolve, as well as return the 2 original performance guarantees.
Yes.
That's the subject matter of his arbitration. Now, my lord, the order under section 9, that's at page 212, annexure O. My lord, here, my lord Justice Bhattacharya has heavily relied on the Delhi High Court. I would show that the Delhi High Court favors me.
Yes.
That day I was in a bit of a rush. I had to go pick up my daughter from the school. Suddenly, Justice Bhattacharya's list collapsed, and whatever happened, be that as it may. But he cannot say it is no longer res integra because it has been decided in an ad interim order. Then directions for affidavits do not have been given. So now, my lord, this is on 19th of July. He obtains this order, stays reticent, does not say this cannot be carried to arbitration because the arbitrator cannot grant me similar relief. Now, the next order by which it is referred, which is at page 222, order dated 7th of November.
Yes.
After almost 4 months,
Yes.
the interim order which has been passed by a predecessor judge is well reasoned. There has not been any appeal therefrom. Our arbitrator has been appointed. Under such circumstances, interim order will continue for a period of 3 months. In the meantime, the petitioner will approach the learned arbitrator by filing an application under section 17 of the Arbitration and Conciliation Act with interim prayers. The learned arbitrator is requested to decide the scope of interim prayers made and dispose of the application within the aforesaid period of 3 months, independently without being influenced by the observations. And they were allowed to file a separate application. They do not file a separate application. This, they call upon the arbitrator to treat as an application under section 70.
What?
The section 9 petition, which I just showed to your lordship, which is at page 171. That they wanted the arbitrator, they were given
They have not
liberty.
filed the application under section 17.
They were given liberty, but they did not choose to do so. They called upon the arbitrator to treat this section 9 application as a section 17 application.
How can you?
My lord will kindly take the minutes now. Minutes today. If I am wrong, Mr. Chaudhary can correct me that if they had filed a separate section 17.
My lord, these are directions given on the first day when I was not present. Lord, from the second day I appeared, what I am given to understand, and from the second day I could understand that's correct. Section 9 application, since affidavits were completed, which were treated as the section 17, and that was taken up for
Affidavit completed with regard to
section 9. Since affidavits were completed
before the arbitrator.
No, before this court.
Yes, so my lord, when the matter went before the arbitrator, I think it was agreed, or my lord, the arbitrator suggested, or the parties suggested. First day I wasn't there. Second day, my lord, when I went, this much I understood, that section 9 application is being treated by the arbitrator as a section 17 application because, my lord, affidavits are already completed. New application was not, my lord, necessary to be filed. Yes. Yes, I'll just read out. Mr. Rishabh Banerjee, learned advocate for the claimant, submitted that an application for interlocutory relief was made before the Honorable High Court at Calcutta has been disposed of by giving interim protection till 3 months from 7th November 24, subject to appropriate order in that regard passed by the arbitral tribunal. He therefore submitted that he has to place his application before the tribunal before pressing the statement of claim. He added that he may be permitted to use the same pleadings for the application which was pursued with limited relief before the Honorable High Court, being AP number such and such. Mrs. Bagri, the learned advocate for the respondent, has no objection to the submissions made by learned counsel for the claimant. Mr. Banerjee submitted that he has more prayers of interlocutory nature, which he shall praise by his separate application. Mrs. Bagri has no objection to the same pleadings being used for the purpose of interlocutory application. By consent of parties, date of hearing is fixed on 6 January at 3:30. Parties, not virtual or such and such. 6 January I had appeared.
My basic point was this section 9 was they wanted the learned arbitrator to treat this section 9 application as the section 17 application. There was no modification. For further prayers, they intended to file separate applications for the 17. Now, my lord will kindly take the minutes.
Where is the
Just
minutes?
have 1 minute. I'll print and submit a copy.
My lord kindly takes the minutes. And whether this tantamounts to a leave under Order 23, Rule 1, Sub Rule 3. Because Mr. Chaudhary yesterday made scurrilous allegations against my...
You are appearing for the defendant number 1.
I'm appearing for the defendant number 2. No. Here now the bank, that has been role has been reversed. Now the bank is defendant 1.
No.
Why not will kindly see in the plaintiff defendant 1. Now the bank is 1. In section 9 bank was 2. Profound.
So you are appearing for 2.
I'm appearing now for 2.
No, 2 is not appearing.
1 is not appearing.
Yes. In the arbitration, they are not the party.
They never appear. Banks do not appear in these matters.
So, Mr. Chaudhary is not here.
Mr. Chaudhary is not here. Banks never appear. Your Lordship will see most of these orders, unless it is something like Citibank or HSBC, foreign banks, but banks generally do not appear in bank guarantee matters.
Yes, next.
Now, my lord kindly looks at this minutes. Mr. Chaudhary made scurrilous remarks against my allegations against my junior yesterday, but I will read from the documents. I don't need to go beyond documents. And whether this tantamounts to a leave under Order 23, Rule 1, Sub Rule 3, let us just see. In the minutes of the meeting dated 6th of January 2025, it has been inadvertent. I'm not going. The remuneration.
Name.
Sorry, I will not. Mr. Chaudhary learned. Remuneration.
Remuneration of
payment to Mr. Chaudhary. The third meeting, sir. Mr. Chaudhary, learned senior advocate, submitted that his client has been advised to file a suit. Now, apropos this, let us look at the provisions of Order 23. Restricted to the relief of a preventive injunction, restraining the respondent, that is Bengal Energy, from invoking the bank guarantee. He added that such a suit has already been filed. My lord, Order 23, Rule 1, Sub Rule 3 says you have to first take the leave and then file the suit. He, as such, does not press the application. Today, I will submit before your lordship that even the interim order is gone. Because Section 17 was a continuation of Section 9. He has withdrawn it. There is no interim order subsisting today.
Right. I'm admitting it. He's correct. Interim order is really technically looking at it. Not, I was thinking about it. It's not there.
That's why I wanted to put the question when you were not there. Mr. Avasti was there. That's once you pray before the arbitrator to treat the Section 9 as a Section 17.
Yes.
And subsequently, you have withdrawn the Section 17,
yes.
Section 9 as a Section 17.
Yes.
And in the Section 9, bank was the party.
Yes.
In the Section 9, bank was the party.
Yes.
Now, and as per this order, now you kindly come to preventive injunction restraining the respondent, the Bengal Energy, not the bank. Kindly see that.
Yes, I know, my lord.
Then how it can be? You are proceeding the arbitration against the Bengal Energy, and you made the whole submission that the bank is the tri-party. The arbitrator cannot pass any order against the third party.
Yes.
The bank is not. Now you made a prayer relief injunction restraining the respondent, that is Bengal Energy.
May I explain in 1 minute? What is my submission? My submission is that bank is a necessary party. My lord, that means it has to be decided in the presence of the bank.
Okay.
Number 1.
Number two, what is the order that I am asking for? I am praying for an order in personam. In personam. But that order in personam against Bengal Energy is not possible in the absence of the bank. The question of my cause of action for obtaining an order, the bank guarantee injunction can have two prayers. A, restrain respondent number one from invoking guarantee or receiving payment, and B, restrain respondent number two from making payment. In section 9, you can only make the first prayer, that restrain the beneficiary from invoking or receiving payment. But that must be heard in the presence of the bank, because the cause of action for obtaining the relief is the bank acting despite knowledge of the fraud.
Okay.
That's the only reason. This is, otherwise it's not possible.
Okay. Yes, continue, Mr.
Now, my lord, restraining the respondent from invoking the bank guarantee. He added that such suit has already been filed. He does not take leave. He files the suit. He as such does not press the application under, my lord, kindly notes this. He had moved this application. That's what this minutes at least record. As such does not press the application under section 17, which he had moved on 6/1/2025. He should have impressed upon the learned arbitrator that even in section 17, this order can be passed under section 9, can be continued. And if he was aggrieved, his remedy was to come under section 37. He cannot, having elected to go for arbitration, he cannot withdraw it and now file a suit and make the same self-relief and says, continue this order. The application is as such dismissed as not pressed. Insofar, this cannot be, I will rely on a Calcutta High Court division bench. This says this kind of a, my lord, observation by any forum is subject to maintainability. Insofar as this tribunal is concerned, the claimant is granted liberty to apply for preventive injunction before such forum as he may be advised. No leave given. And this is liberty before such forum, which is the forum. The maintainability of the suit has to be now decided.
Yes.
Now, my lord, 2 or 3 things which I would show from the merits of the matter. Now, your lordship kindly takes the copies of the guarantee. And I would rely, before that, my lord, 2 or 3 things which I should indicate to your lordship. Certain dates are important. My lord, 18th of June, your lordship can make a note of this, which is at page 99 now 130. 130 of lordship's petition, volume 1. I would admit that the bank guarantee is a conditional one. I would admit that. I will show the bank guarantee clause. And the validity of the bank guarantee has not expired.
Not expired?
No, I'll show that. My lord, gives me a moment. My lord, I do not know. There are 2 pages. 99 or 130? 130. Is it a letter dated 18th of June, my lord? 99 in printed format?
No. 19 June 132 is the email.
My lord, it would be 99, my lord. My lord,
130.
Chaudhary heavily relied on Sarguja transport.
And
he had learned constitution in 4 hours time, and my uncle was shocked to hear this. So we were studying together, and he asked me, 4 hours is good for constitution. My uncle said, I have given my entire life, I couldn't understand the constitution, and 4 hours is good enough. But
130.
Petition page number 130, my lord. Petition.
It will be 90. Yes. But on Sarguja transport, I'll just give a passing reference. That was a writ petition that was withdrawn without liberty and Article 32 was filed. But there is a difference, madam. According to Baba Saheb Ambedkar, the most important of the fundamental right is Article 32, where you can move the Supreme Court, which is your fundamental right if your fundamental rights are infringed. Because that is a fundamental right.
But even then, Supreme Court did not allow. Without leave.
Even
then, Supreme Court did not allow, despite what Baba Saheb Ambedkar said.
Because you already invoked the fundamental right. You are
Yes. And say,
despite that,
go get leave, as
despite
Jishnu Chaudhary has got from Justice Gupta.
No, you haven't got any leave. I will show. But at page,
Still he said that.
page 99, I had to keep pata 99 actually. 99.
Yes, 99.
My lord, this is a letter of 18th of June. I write to the bank for encashment of the bank guarantee. Now kindly see the bank's response to this, which is at page 110.
Yes.
If it was a public sector undertaking bank, they wouldn't have taken so much of caution.
Yes.
Invocation has been taken up with your good office as per unconditional invocation guideline of RBI. But post highlighting the specific clause, we have taken up with the beneficiary about non-compliance of the clause and seek further clarification. Because the condition precedent was I have to give him a notice asking him to remedy. That has to be accompanied by with the invocation letter. Accordingly, the beneficiary confirmed about withdrawal about invocation claim and informed that he will be presented if need post compliance of your clauses, and this is for your information. After that, I write to him. Then my notice again goes to him on 20th of June, which your lordship will note is at page 150. 150.
Yes.
Here I describe what are his breaches, but that's the bank that the bank is not entitled to get into. The moment I make my demand, accompanied by the conditions, the bank will have to. Now, my lord will kindly see the. We said we are no longer. I give him a fresh. Yeah.
That's a page 70. Yeah.
My lord,
Page 70. Page 70. 70.
70. My lord will now kindly see the bank guarantee, which is at page 70 of the.
What is your reply? 150 or wanted to show what you want to show in the
No, because now, so what happened? The condition was I have to give him a notice.
Correct.
Then only I can invoke the bank guarantee by attaching that notice. I gave that notice on 20th of June. He invokes the bank. He invokes the arbitration on. He invokes the arbitration on 21st of July.
160.
8 July. Sorry, I am sorry. 8 July.
8 July.
11 July, he files the section 9. 19 July, because I have to give him 30 days time. Before I could give bank the notice that, see, now I have complied with the condition. Now kindly invoke it. He comes and he gets this order of restraint against me. Now, my lord kindly looks at
the first notice was issued
18th of June.
18th of June. Correct.
19th.
And bank has written that.
My lord, I am sorry, maybe I have been unable. 18th of June, I invoke the bank guarantee.
Correct.
19th of June, the bank says the invocation is not in terms of
comply with the direction. Yes, comply with the conditions.
The condition precedent in the bank guarantee is that I have to give him 30 days notice. My invocation has to be accompanied with that notice.
Correct.
That notice I issued on 20th of June.
Correct.
And I asked the bank, do not do anything. I have realized it is a mistake. 20th June, 8th of July, he invokes. 11th July, he files Section 9. 19th July, because the 38 days period would have been over on 20th.
20 July.
20th, he moves the Section 9, 19 July, and obtains an interim order even before I could invoke the bank guarantee in terms of the clauses of the bank guarantee.
Correct.
Now, my lord will kindly see page 70. This is the bank guarantee.
Yes.
Now, there are. Now, my lord kindly takes page 71. My lord, fourth paragraph. This is the condition precedent. I'll just show the bank guarantee, and my lord, tomorrow I will just take 15 to 80 minutes. 15 minutes. Now, therefore, we the bank hereby unconditionally and irrevocably undertake and guarantee to pay to the beneficiary under this performance guarantee any amount up to an aggregate value of rupees 3,25,00,000 against any loss, damage, costs, charges and expenses caused to or suffered by the beneficiary by reason of non-performance by the supplier of the terms and conditions of the said contract without any contestation, demur or protest, or without questioning the legal relation subsisting between the beneficiary and the supplier upon receipt of a simple demand from the beneficiary by the bank on or before 26th of June 2024, indicating the amount to be received by the beneficiary, mentioning therein that the supplier has failed to perform its obligations before the expiry date of the guarantee under the contract, and the contract is still valid and binding. The demand should be, well, this was my mistake. The demand should be accompanied by a copy of the beneficiary's letter to the supplier giving 30 days notice during the guarantee validity period to make good the deficiency, and the certificate from the beneficiary, which is my client, certifying that the period of 30 days has elapsed.
Correct.
Now this is where my lord, the interpretation of the bank guarantee comes in question. This is in the merits. Now, my lord, kindly take page 71. My lord, a non-obstante clause in the agreement. Notwithstanding anything contained herein, our liability under this guarantee shall not exceed 3,25,00,000. This guarantee shall be valid up to 26 June 2024. And we are liable to pay the guaranteed amount or any part thereof under this guarantee. Now, my lord, kindly mark this. Only and only twice only. If you serve upon us a written claim or demand in terms of the guarantee on or before 26 June 2025. Now, my lord, when there are two clauses of contract of the agreement, first of all, this is a non-obstante clause. My lord knows that the document has to be read.
If the guarantee is valid only up till 26th of June
2025,
the bank guarantee.
But I can make a claim, and this is what the Delhi High Court has held. I will rely on it. The point before Delhi High Court was there. The clause said you have to. The bank guarantee was till 12th of January.
What was the liability period?
I am telling you about it. The clause said you have to file a suit by 12th of February 1997. My lord, in 1997, the Contract Act underwent an amendment whereby Section 28 of the Contract Act was amended, which said that the period of limitation in filing suits cannot be abridged. The Delhi High Court held, yes, this clause where it says that you have to file the suit by 12th of February, though the term of the bank guarantee expired in January 1997, this cannot be enforced because it is violative of Section 28. But what Delhi High Court held, that you should have at least made a demand before 12th of February. But what the principles of contra preferentum says that the document, if there are two contradictory clauses, it has to be read against the maker of the document. But in terms of guarantee, bank guarantee and guarantee, I have decisions of Supreme Court to show that the terms has to be read against the guarantor, which is Mr. Chaudhary's client. But tomorrow I will just take 15-20 minutes.
I'll just leave you, Your Lordship, with one thought. After hearing this for such a long time, I'm sure it will play on Your Lordship's mind in the evening. Just this one sentence.
Lordship has better things to do.
No, I'm sure, but it comes up. We are involved in litigation. It keeps coming back. If I had filed a suit before Your Lordship, and if Milord had come and said that I find that there's a problem, or maybe there's no problem, some reason, XYZ, doesn't have to be that you didn't have jurisdiction to entertain my first suit. You give me leave to Milord file another suit. If I file the second suit, is there a problem? The answer is no. Same thing, arbitration is equal to suit. Same thing. Milord, that is how, Milord, I'm going to answer all his arguments in, Milord, very brief time. That once the leave is given, nothing remains. Only thing, Milord, I'm sure he is not going to invoke the guarantee by in the evening.
Invoke I'm
sure he won't.
Tomorrow, my lord, if it can be post lunch, my lord, I have a doctor's appointment in the first half. Either I'm done by 9:30 or your doctors make us wait till 11:30. My lord, if it can be post lunch.
After the commercial after फ्राइडे नहीं फिर वो लास्ट दिन हो जाएगा फिर छुट्टी हो जाएगा.
Technically speaking, my learned friend is correct. There is no interim order today. I have no difficulty with that. As long as he ensures.
My lord,
I have no, listen. Don't be embarrassed. I have learned the hard way. I came and gave an undertaking and I found documents had been put in for registration. So don't get embarrassed. After that, I've stopped giving undertakings.
इस तारीख परसों 2 खाली है. So appearing for the plaintiff. So appearing for the defendant number 2. Counsel for the defendant number 2 has argued at length, but due to paucity of time, hearing could not be completed. Release the matter on 30 January at 2 p.m.
No, at least kindly record his statement that it will not be done till the conclusion of the hearing.
My lord will kindly
on instruction, learned advocate appearing for the defendant number 2 submits that they will not invoke the bank guarantee till the disposal of this application. This application.
Item number
not disposal till further order, if any, passed by this court. Till further order, if any, passed by this court. Disposal, then it will go.
Yes.
My lords, kindly to mention item number 13 of my lords commercial. 13.
Yes.
My lord, it gives 2 returnable dates. My lord, on the safer side, my lord, I'm mentioning for the extension of interim order. The first,
why it is fixed today?
The first page says returnable 31st or until further order. The second page says 28th. So it has come to and mentioned on the
devoted
safer
to
side.
file appeal in opposition within 2 weeks, winter vacation.
Kindly see the last line and the 2 dates given for returnable.
Extended till 31st.
31st, but or until further, and the next page says 28.
Correct.
So on the safer side, I'm mentioning for the extension of interim order.
Interim order till 31st. 31st is Friday. Let it be on that. That is with regard to the your affidavit.
Then kindly makes the correction because it's 2 dates those are being given.
Dependent
extends the interim order.
Defendants are directed to file affidavit in opposition.
That they have not been done. Again, sir, though there is no direction on my advocate on record to give.
Who is for the other side?
They are not being appearing consistently. If this is the second affidavit service that I can file.
Okay, you come on 31st. Come on 31st. I will see. They're already there.
Very well. Then matter appear on 30th.
Well, item number 14, my lord. Huh? Item number 14, interim order is, my lord, expiring today, my lord. Item number 14.
Which for the other side?
My lord, none has appeared, my lord.
Item number?
14, my lord.
14, so and so,
May I file my affidavit of service, my lord?
Affidavit of service filed by the plaintiff be kept in the record. Full stop. Counsel for the plaintiff submit that the interim order was earlier is going to be expired today and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 18th of February 2025 or until further order, whichever is earlier. Let the matter remain in the list. Yes.
May I have the liberty to mention item number 22 of the commercial list today, my lord? Yesterday, we had agreed to an adjournment because the other side had a problem. It went down in the list. May it, my lord, appear, my lord, at some position so that it's taken up Friday, my lord. Clients come from Nepal, my lord.
What is the matter?
Well, it's a recalling application. One of the defendants said ex parte by your lordship's order. Other, my lord, defendant lordship said, because I have asked for recall of the order by which he was added, lordship said I'll decide that application and thereafter, my lord, I'll.
Who is for the other side?
My lord, I am not mentioning upon notice, but I can give them notice if lordship, my lord, allows upgradation on Friday, my lord. Because they come from outstation, my lord, I was only, my lord.
What they want?
If one of them, my lord, travels from Nepal, my lord, advocates come from Delhi, my lord, if we have a definite, my lord, time or my lord, date, then it's convenient for the parties and their my lord, the advocates.
Time to nahi hoga na.
My lord, Friday, if it is at the top, my lord, I'm sure it would be called because
2 matters are there Friday. Already 2-3 matters are there. ठीक है, इसको देख लेना, जितना जैसा अगर टॉप होगा तो उसके बाद रख लेना इसको.
Grateful, my lord. Item 22.